Therefore, I don't item numbers 1 to 3. The numbers 4 to 11.
May I please, my lord? I beg to, with the consent of the other side, my lord, I beg to mention item number 4, my lord.
Why?
My lord, the leading counsel, P.N. Kusum is some difficulty, my lord.
He stated that arguing counsel Mr. P.N. Goswami is not in a position to argue the matter today. A request is made to adjourn the matter. List after 2 weeks.
Lordship, I'm appearing on behalf of the petitioners. Your Lordship, the interim may.
You are for the
Yes,
petitioners.
Your Lordship.
All right. Appearing for you, Mr. Goswami appears for the respondent.
Yes, my lord.
Forest Department.
Yes, my lord.
All right.
Interim may continue.
Interim order shall continue. List, then we'll post it in at the end of July.
Hello.
Yes.
List in last week of 4th week of July. Interim order shall continue till then.
Nothing, Lordship. Item number 8, Lordship.
Mhm.
India's counsel is from Delhi, Lordship, and he is not well, Lordship. So matter may come after 2 weeks, Lordship.
Why Mr. Ken Chaudhary is here?
I'm for respondent,
Lordship, I'm
Lordship.
for-
3 and 4.
So why do we need a counsel from Delhi? Why don't you yourself argue?
Lordship,
Why?
he is
You think yourself to be lesser than Delhi counsel by any means.
No, Lordship, he filed a case, Lordship.
He is for the respondent.
Respondent.
He couldn't have filed the case.
No, Lordship, he is in a case, Lordship. In fact,
All
he
right.
filed wakalat number, Lordship.
They stated that arguing counsel for the respondent, appearing for the respondent number. Which respondent?
3 and 4, Lordship.
Respondents number 3 and 4 is not available today. Prayer is made to adjourn the matter on his behalf. List up 4 weeks.
Yes, may I please, Your Lordship. Could you confirm from other side, Your Lordship, effective means item number 13, Your Lordship.
13.
13.
Why?
In this case, Your Lordship, the petition appellant has newly engaged the senior counsel P. Bora. Maybe after 1 week.
A request is made to adjourn the matter on behalf of the Byland Council, so and so appearing for the appellant. List up 4 weeks.
Up 2 weeks. And
You want to argue it today. The matter is on board.
Lordship.
Yes.
May I please, your lordship? With the consent of other side, I beg to mention item number 17.
17.
For, my lord, any date, my lord, in the next week, my lord.
Why? Why not
My lord,
today?
Today, my lord, my senior, my lord, he has some difficulty, my lord, M.K. Chaudhary, my lord.
What kind of difficulty?
He is contacting.
Oh. All right. List after 1 week as prayed.
Oblige, my lord.
Democracy is actually.
My lord, I beg to mention read appeal, my lord, for listing on tomorrow, my lord.
What is the matter about?
My lord, this is regarding selection of associate professor in MBA department, Guwahati University, my lord.
Hmm.
So, my lord.
When was the order passed by single bench?
My lord, on 12/5, my lord.
All right. List it. Why tomorrow? Have it on Monday?
My lord, tomorrow is, my lord, the executive committee meeting will held tomorrow
Hmm.
for selection of the respondent number 4, my lord. That's why, my lord. I
All
need
right.
tomorrow, my lord.
Tomorrow.
My lord, I prayed for listing of this matter, my lord. This matter pertains to, my lord, tribal belt and block under chapter 10, my lord, and related with, my lord, item number 2.
Related with 1 and 2.
2, my lord, item number 2.
So you want it to be listed today?
My lord, on the next date also, it may be, my lord, take.
What is the next date fixed in the matter?
My lord, not yet fixed, my lord.
Not yet fixed. All right. Get it listed on Monday or Tuesday.
Yes, my lord.
Okay.
Always.
Recusal? 16. Honorable Justice. List before a bench of Honorable Justice. A.D. Chaudhary is not a member. It's your judgment or what?
Item number 1 for orders.
Please.
Yes, please.
In this case, your lord, this PIL has been filed against the illegal extraction of stones from the Madura riverbed in the district of Kasar, which is already banned by the Honorable Court.
Yes.
In the judgment, your lordship, in 2010, banned it. And the Honorable Court, Your Lordship, can take commission of this court, 2 members. Vice member as a commissioner to send this for verify this report
Yes.
and submit report, and they have filed their report.
Okay.
And they found that there's some
What is the present status?
present state, Your Lordship, they have only to mislead this Honorable Court. They have settled one nala, Your Lordship, and extracted the stone from the mine area, Your Lordship, band area, Your Lordship.
Hmm.
And which is not possible to extract that, Your Lordship, settled area. And this report also found is clear, Your Lordship, regarding
Report of
the commissioner, Your Lordship, of this court.
that commission cut off the cut again. Okay. Mhm. Okay. Mhm. Hmm. The government, no?
Government filed an affidavit.
Yes, the government's affidavit.
Plus,
Would you like to file a counter of this affidavit? Because government says that all right, we have taken care of the things and they have questioned the veracity of this report. Have you got the affidavit of government?
I have repeated, Your Lordship.
Read please. Let's have a look at the report. The affidavit.
They have filed 2 affidavits here. Earlier, they have filed one,
The affidavit at page number 340.
341, Your Lordship. I am reading 341, para 1, Your Lordship.
Yes.
The deponent is presently serving as the principal.
Oh, why do you read this?
Right.
We don't bother about the
you
place he is serving. What is the content?
Content, Your Lordship, is para 3, Your Lordship.
Hmm.
Para 3, I am reading, Your Lordship, this 341 page.
Yes.
That thereafter 2 members committee submitted the report wherein allegation have been leveled against the department. And the investigation has also been recommended solely on the ground that previous reports prepared by the department were not in conformity with the findings of the committee. In this regard, the deponent is
Who is appearing for comment? On what basis do you question the veracity of the report?
On two,
I have read that.
two grounds, Your Lordship.
Yes,
When the committee members visited the site, Your Lordship,
yes.
on behalf of the petitioners, a person.
So he has an interest, no doubt.
No,
The petitioners have an interest in this case.
Yes, they.
That is
they-
a public interest there.
No,
They are espousing.
the person who claimed to be representing the
Yes.
petitioners.
So merely because of that, the veracity of a report prepared by the learned advocates for officers of the court, that is to be doubted.
No, because the broader perusal of the report, Your Lordship, would reveal that they were taken around the site by this person, Your Lordship, who has a direct commercial interest in stopping mining.
Were your officers not present?
Our officers were
They were
present.
present. What kind of objection did they mark in this commission's report? Let us see. And when for the first time you came out with this aspersion that the report is biased
In the affidavit.
in the affidavit, what you were doing for so many days?
There was.
Why didn't the light dawn on you earlier?
Because perhaps the person, Your Lordship, that he had participated earlier, that fact had perhaps escaped the government. Your Lordship.
Escaped.
Yes,
It came to knowledge later.
yes, but that this person who was representing the petitioners, that he had participated earlier.
The findings of the report are not correct. When is this allegation leveled?
Prima facie, what we have said, Your Lordship, is that
Yes.
the findings are based on, apart from this aspect that the person who led the petitioners,
Hmm.
led the group is interested,
Hmm.
we are saying that the findings are based on surmises and conjectures. There are lots of ifs and maybes in the report, Your Lordship.
Hmm.
So there appears to be some contradiction in the report, but even beyond the surmise and conjectures, Your Lordship, what the report has finally said, Your Lordship,
Hmm.
which is at page number 387.
Read.
It is observed that, I'm reading the second paragraph at 387.
Yes.
It is observed that stone mining took place in Madhura River under the garb of
387 of your affidavit only.
387 of the affidavit. Your Lordship.
Yes.
It is observed that stone mining took place in Madhura River under the garb of operation of Dora Nala MCA and Thaikul Nala MCA earlier in 2019-20. It was only on visit of present DFO to the area on 31/8/2021 that the matter was reported to the higher authorities in the forest.
You are representing the mining department or forest?
Only the forest department.
Okay.
that the matter was reported to the higher authorities in the forest department that the area was not revenue area as shown in the NIT, instead a dense forest area. Mining was not possible without breaking up the forest area and same would violate the Forest Conservation Act 1980. No detailed environmental study of the Madhura River and its catchment was made to ascertain mining area and volume of mining. Therefore, although operation of Doram Nala MCA and Thaikul Nala MCA was shown on paper, in all probability, because again, it's a maybe, extraction took place from the Madhura riverbed, more particularly near the Madhura Doranala entry confluence. As stated in the preceding paragraphs, Thaikul Nala lies at the upper reaches at the end of the Doranala. Flying off dumpers from the confluence
Is
of
the mining department a party?
No, Your Lord.
Include the mining department. This is basically your allegation is misuse of the mining lease.
Lordship, one aspect, Your Lordship.
Yes.
This mining lease is granted by the Forest Department under MCR.
All right, you have granted the mining.
Yes,
lease.
yes.
All right.
Thaikul Nala lies at the upper reaches at the end of the Doranala.
Mhm.
Flying off dumpers from the confluence of Madhura Doranala is impossible due to presence of large boulders and inaccessible terrain. And
All
as
right,
such-
so what we do is, we direct you to install trap cameras in the
Yes.
entire route.
Yes,
They will have the video footage,
yes, yes.
then that will be sufficient.
Yes.
All right. What do you say, gentlemen?
Presently, as per my
And
instruction.
just the next paragraph also, Your Lordship, would perhaps be
Yes.
relevant. It is observed that the present DFO Kachar division, after joining on 23/7/2021, recommended cancellation of the e-tender of Doranala MMU stone, which was tendered on 7/7/2021 by this communication dated 18/8/2021, being letter number so and so, addressed to the CCF Southern Assam Circle. In the said letter justifying the cancellation, the DFO inter alia stated that Doranala is actually a tributary of the Madhura River. The route leading to the area is through Madhura River, and hence there might also be potential illegal extraction from the Madhura River.
Hmm.
Again, on 26/10/2021, the DFO formally cancelled the e-tender of Doranala MCA.
That has been cancelled already.
Cancelled.
Subsequent, this is subsequent.
So all right.
Earlier, they had set it 2019, that we
Now we have
filed it.
cancelled.
Already they have extracted the whole.
So except for that criminal action you want, you need proper evidence, go file an FIR. What a PIL will do for that. Now the mining lease has been cancelled. At best, we can ask them to remain vigilant that no illegal mining takes place. Or ask your clients to be vigilant. If they get the evidence of illegal mining, that can be dealt with. But now what remains to be done?
It's clear, your statement of the laborers, they also stated in page 372, your lordship, and 73,
Yes.
372,
Hmm.
the affidavit. Statement. 372, can be your lordship.
Yes.
The statement of Dana Borman, of who is a villager, your lordship, got paragraph 9. Who is a villager, a laborer, it appears that he used to collect stones from the mother river bed and load with the trucks for a maholda, it is settlement holder. And trucks came up to the Tavaposti. At present, there is no extraction as Mahal is closed about 6 months ago. Presently closed, but earlier they have already extracted the river bend area. lordship.
Understood, sir.
There are no roads loading to.
Is there a positive evidence to that effect? That the extraction has been done? Whether that aspect can be examined in a PIL, that earlier there was illegal extraction, so penalize those people. Is that leaseholder a party?
Lordship party. your lordship. Settlement, respond number 7.
Respond number 7.
Lordship.
No response on its behalf.
No response. your lordship. Fact is that there is no road to Thaikal Nala. It is the hill area, your lordship, there is no road. But for misstating the honorable court, they have settled the Thaikal Nala. It is
Ultimately,
upper
no,
the-
gentlemen, it's a
and
disputed
extracted
question
the
of fact, whether the mining took place during the pendency of this petition or earlier, what was the exact duration, what was the quantum of the extraction done. These are disputed questions of facts.
During pendency of this court, they always said, after that, they have closed your lordship.
Have you given any photographic evidence?
Earlier, I have given your lordship photographs.
Where?
Your lordship. Page 120, your lordship.
120.
120, your lordship. By using machinery, your lordship. 120.
What is the date of these photographs? They are not dated. By merely looking at these photographs, can the location even be identified?
Lordship, I have written your lordship.
Coordinates are not there.
Right.
So This can be of any river or any nala for that matter.
Then even if you compare it.
No, they say that mining lease is not cancelled. Court remains. We'll close it and we'll advise the mining department to remain careful and ensure that no illegal mining activity takes place. Okay? Okay, very well. Closed. Pass the order.
Item numbers 2 and 3.
Here, your worship, BPC has filed in one affidavit, your worship. They said yesterday, that is only in respect of one district, your worship.
Yes.
It has no reference to the rest of the 3 districts under BPC, your worship. And out of your worship, one district, they say 300 bighas out of 18,000 bighas of encroachment they have cleared, your worship.
They have cleared.
They have on 300, your worship. And your worship, so far as other 3 districts are concerned, your worship, Tirang, Batsa and Udalguri, there is no reference in this.
Lordship, in this, Lordship, only we have evicted only 300 because of land. Other district yet to evict.
The
Lordship.
action is still pending.
Pending.
When will you be able to complete that action?
Lordship, in this regard, Lordship, I need some time, Lordship.
Where is the affidavit?
Affidavit.
You have it today? Affidavit has not come on record.
I have e-filed also, Lordship.
Is there? Yes. Which districts the work, the action remains to be taken?
Baksa, Chirang and Udalguri.
Non-comment advocate M. Bora has filed an affidavit of the Principal Secretary BTC Kokrajhar, which indicates that the authority launched an eviction drive and has got 300 bighas of land removed,
Real.
freed from encroachments. However, the affidavit is silent. Our land council, Mr. Botakur, submits that the affidavit is silent regarding the steps taken to remove the encroachments in the districts Baksa, Kokrajhar and
Baksa, Chirang and
Chirang and
Udalguri.
and so and so. MS Bora submits that some more time may be allowed so that the authorities can take appropriate steps for removing the encroachments on government lands in these districts.
Not on government land, your lordship, tribal belt and block.
Tribal belt lands in these districts also. One further opportunity is being granted with the direction that the authorities concerned shall ensure that the lands of tribal belts which have been encroached upon shall be freed from all encumbrances and encroachments. List on 23rd June.
My lord, in the morning, my lord, I mentioned that, my lord, WPC number 4901, my lord, My lord, this case may be tagged with my lord.
along with the file of WBC number so and so shall also be listed along with these two writ petitions, PIL petitions.
Much appreciated.
Matter number 5 and 6 for hearing.
This matter relates to Lordship the 90th decade,
90s.
90s, because there were some communal clashes in Bongaigaon, Kokrajhar districts, Lordship,
Okay.
and there were large number of affected victim families.
Mhm.
All were accommodated in some makeshift temporary camps under the government's arrangement, Lordship.
All right.
And phase wise, we have able to relocate the persons who are affected. If Lordship is pleased to come to page 54.
54.
This order was put to challenge. Peruse the order dated so and so, so and so. Also peruse the writ petition submitted to the Honorable Court in WPC 4172 by Relief Families Welfare Service Society.
You are
On
reading
behalf of-
54,
Page 54,
annexure 6
Annexure 5.
is some pagination issue. This is annexure 5, page 52. All right.
Order dated 31st March 2011.
Hmm.
This order was passed in terms of the Honorable High Court's order.
Okay.
The Honorable third paragraph I am reading, so I am reading from paragraph 2.
Yes.
Mr. Devnath Learned Counsel for the petitioners has contended that the government of Assam in pursuance of the order of Honorable High Court dated 22/1/2007 in WPC so and so has paid 10,000 to the petitioners. He has contended that the government of Assam has decided to enhance the amount of rehabilitation grant from 10,000 to 50,000. The petitioners prayed for enhancing the rehabilitation grant from 10,000 to 50,000. This is the core issue, Lordship. The Honorable Guwahati High Court has directed the government to verify as to whether government enhanced the amount of grant to the affected families from 10,000 to 50,000 and whether the petitioners Relief Families Welfare Society
Are
are entitled
to
for
the
the
same.
same.
All
The
right.
Honorable High Court has also ordered that while doing so, claim of the petitioners in WPC 2991 may also be.
So how
taken
was
up.
this amount quantified? What was the basis?
There were some enquiries and there are there are 4 types of victim families. This I'm coming a little bit later, Lordship. A huge portion of the population in the erstwhile Kokrajhar districts were affected by the ethnic violence, which broke out in 1996 and 1998.
Mm.
Most of the affected families had taken shelter in different relief camps opened by government of Assam. However, in course of time, with improvement of the situation, most of the families returned to their respective villages. While some families obtained rehabilitation grants, some families left camp without waiting for rehabilitation grant, but still several thousand families could not return to their villages and continue to reside in the relief camp.
Mm.
The petitioners were affected by the ethnic violence in the year 1996, but they had returned to their respective villages and continued to lead normal lives. To rehabilitate 38,364 number of families who could not go back to their respective villages and stayed back in the relief camp, the government of Assam had prepared 4-phased action plan and proposed to Government of India to release funds by providing rehabilitation grant to each of the families at the rate of 10,000. The composition of the phases are as follows. Phase 1, families owning patta land or previously residing in the recognized forest village who could go back without additional security arrangement were included in this phase. Phase 2, families owning patta land and previously residing in the recognized forest village but could go back with some additional security arrangement were indicated in this phase. Phase 3, families owning patta land and or previously residing in the recognized forest village who could go back with additional separate security arrangement in each village or in cluster of villages were included in this phase. And phase 4, family who either had no patta land or were not resident of the recognized forest village were included in this phase. These families required arrangement of land for rehabilitation. However, suitable land for rehabilitating these families included in the 4th phase could not be arranged, for which such families continued to live in different relief camps of erstwhile Kokrajhar district. Moreover, a few thousand families affected in 1993 ethnic violence who had no land of their own to go back and continue to reside in the relief camp of erstwhile Kokrajhar and Bongaigaon district. They had become a recurrent liability to the government of Assam since gratuitous relief in the form of food stuff, blanket, mosquito net, etc. are provided to them regularly besides providing them basic civic amenities at the cost of the exchequer. Petitioners at paragraph 9 of the writ petition have contended that they left relief camp after normalcy of situations, and as such, obviously, they are not eligible for inclusion in of the phases since they were not residents of the relief camp when the action plans were drawn. Some families who left camps on return of normalcy situation and whose names were not included in the action plan approached the Honorable High Court in two writ petitions, so and so, so and so. The petitioners of the present case. Next page, Lord. The Honorable High Court in both the cases directed the government of Assam to pay rehabilitation grant to the petitioner's family at the rate of 10,000 per family. In compliance of the order of the Honorable High Court, the government provided 10,000 to each of the petitioners. It is not a fact that the government of Assam has taken any decision to enhance the rate of rehabilitation grant from 10,000 to 50,000 per family. In spite of the best of efforts on the part of the government of Assam to rehabilitate the camp dwellers, suitable lands could not be arranged for which the relief camp had to be continued. The hard fact of continuation of the relief camp for 10 to 17 years had turned out to be a sore thumb for the government of Assam. Apart from the recurring financial involvement, the matter of continuation of the relief camp has become an issue in the domain of human rights. Different organizations approached National Human Rights Commission and Honorable Supreme Court of India. So the government had taken a special scheme for rehabilitation of the families still living in the relief camp in the form of payment of an one-time, once for all rehabilitation grant so that they are able to purchase land at any place of their choice. The amount fixed per family was 50,000. The eligibility criteria as laid down were to include only those ethnic violence affected families who have been living in recognized relief camp in Kokrajhar, Sirang, and Bongaigaon district. 2, families who have been receiving GR as per admissible rates every month. The conditions precedent and subsequent to payment were the recipient's family would execute an agreement and affidavit to vacate the campsite and not to stake any claim for relief in future. 2, execute an indemnity bond to indemnify government. And 3, vacate the campsite forthwith. The petitioners who have been living in their own villages and have been leading normal lives, they do not stand on the same board as of the camp dwellers who are residing a non-natural living for 10 to 17 years. The scheme applicable to relief camp inmates is not applicable to the families living in their own village. Under the circumstances, the claim of the petitioners claiming enhancement of RG from 10,000 to 50,000 cannot be accepted. This is our case, Lordship. They are on a completely on a different footing, Lordship. Their status and the status of these dwellers,
They return back to their own lands.
they returned back immediately and they got 10,000 rupees also.
10,000.
And they had their own land, patta land, or they have villages to stay. These people, they do not have any land and government also could not procure. So we have decided that 50,000 as a lump sum amount will be given to them.
Read para 17 of the
Whereas-
page 17, page 28.
70, Lordship.
17,
page
page 28. Or rather, you read the para 17, because in our file, this order is at 2 places.
Conclusion of the learned single judge.
Indeed, the members of the petitioner society,
Sorry, Lordship, I missed the page number, Lord.
just we are dealing with the writ petition number 5324 or some other writ petition.
Yes, 5324.
So para 17, you come to para 17.
Oh,
Internal page 10 of the judgment.
in the judgment, Lordship.
Yes.
Yeah. Paragraph 17. Indeed, yes, Lordship. The members of the petitioner society received 10,000 each by way of rehabilitation grant pursuant to an order of this court in WPC so and so. Whether the said ex gratia payment of 10,000 vis-a-vis the loss as assessed by the government functionaries is in due compliance of the minimum standard of relief to be provided to persons affected by the disaster is an issue which calls for attention and adjudication. Here, the Honorable Court brought in the Disaster Management Act of 2005, which in my humble submission is not required because the issues date back to 1996 to 1998. And they were not getting any compensation, whether 50,000 or 10,000 in terms of the disaster. This is ex gratia amount given by the government.
Hmm.
So therefore, the learned single judge relied upon certain provisions of the 2005 the Disaster Management Act,
Okay.
and also went on to the principles of discrimination. So
Hmm.
if Lordship is pleased to come to paragraph 20, page 31.
Yes, yes.
Steps for a permanent solution towards rehabilitation of camp dwellers after abatement of violence and or after risk impact and effect of the disaster had considerably reduced is a laudable effort if taken within the four corners of law. However, grant of money in the name of special scheme in phase for families to purchase land is a concept not provided under the Disaster Management Act of 2005. So this is not, in my humble submission, is not at all required. Because this is under a different area, totally on humanitarian consideration, Lords.
Hmm.
The guidelines for minimum standard of relief under the said act do not encompass special grant for relief to landless persons to purchase land. Relief can be had only to cover the requirements of relating to shelter, food, drinking water, medical sanitation, as well as ex gratia assistance on account of loss of life, damage of houses, restoration of means of livelihood, and such other reliefs as may be necessary. The statute certainly does not cover relief or rehabilitation in the form of special grant for purchase of land. So if the government is giving this
Hmm.
without taking recourse of the law, it is for the benefit and welfare of the downtrodden people, Lordship, who do not possess any land of their either in a revenue village or in a forest village.
Come to para 21. Para 21.
Yes, Lordship.
That is a
Yes,
question.
that is discrimination
formulated for
issue is
discussion.
there.
Yes.
Be that as it may, in the absence of any challenge posed, this court is not inclined to interfere or question the action of the state government in extending special relief to the families falling under phase 4. The present petition is primarily on the allegation of discrimination on the premises that the members of the petitioner society have been denied equal treatment despite having suffered more setback than the beneficiaries in terms of the damage of their house, cattle, granary, etc. as an evidenced by the damage assessment report of the government functionary. The basic prayer is for direction for rehabilitation grant to the petitioners as the enhanced rate on the basis of the loss and damage assessment report prepared and submitted by the revenue and forest officials. To that end, the prayer is made setting aside the order. In the respect of this, my humble submission was their whole case is based on why one group is given.
Phase 4. Phase 4, why they were given
Yes.
relief and why they were not given.
Yes, it is not
Uh,
because they are getting less compensation. Had
No.
they filed a separate case that 10,000 is not adequate, enhance us because our loss was more.
That is
would
what
have
the
been a
discussion
different
is.
case.
AG sir, that is the discussion in para 28. 28, please read. There the finding is,
Yes, Lordship.
that is
In
the
the
assessment
instant-
made
yes,
by
this-
your authorities.
Yes, this in my humble submission where there is infirmity. In the instant case as indicated above, due assessment with regard to loss and damage suffered by the members of the petitioner society had been made by both the forest and revenue officials. The said assessments were made on account of damage to houses, cattle quantified well above 50,000 per family. The loss suffered on account of destruction of property and or damage to house, etc., arising from man-made causes has to be duly compensated, which is recognized under the provisions of the Disaster Management Act.
Mm.
In that view of the matter, the order under challenge of dated 31/3/2011, rejecting the claim of the petitioner society solely on the ground that the members of the petitioner society had returned to their own village and have been leading normal lives, do not find the support of law. The members of the petitioner society are legitimately entitled to be compensated on account of damage to the houses and for restoration of means of livelihood on the basis of the loss and damage assessment report. I fully agree here, but the issue is, Lordship, their whole contention is that they received 10,000 rupees.
That's not in dispute.
That
So
is not in dispute.
you yourself treat them to be affected persons.
We
that is a-
accepted,
that
but
is a-
their conditions and the conditions of the phase 4 persons are totally on a different
You
footing.
look at it in a different perspective, AG sir. Phase 4 persons, they were basically granted compensation because they were burdened on the state exchequer. You probably spent much more on them while keeping them in the camps.
That is correct.
You wanted to get rid of them. This was basically a golden handshake.
This
All
is a
right, we
golden
give you
handshake,
50,000,
but
leave the
yeah,
camp.
we could have given 10,000 and say goodbye also. But we have
Yes.
to consider their plight, that they will become homeless and they will have
That's true.
shelterless.
Understood. What we are saying is
The government
by-
does not have
by that 50,000 amount, virtually you have washed your hands of a bigger liability.
They are not before this honorable court.
We are not on that. We are not on that. These people, by leaving the camps and resuming their life on their own lands, they have relieved you of a burden.
No, they have happily went away. They happily went away, lordship. There is no more camp now.
There's
They
no
have got
dispute.
a respectable life now. The land price is not like that here in Guwahati, lordship. With 4,000, 5,000, they can procure land there
Yeah, that's all right.
in those places.
Hmm.
So they are happily going. They have left. They cannot be equated on the same footing. They are not on the same
Very well.
platform, lordship.
All right.
And the number is not very little, lordship. 38,000
Read para 4, please. Para 4 and 5.
of the same judgment. lordship.
Yes. How do you deal with that?
Yes. Meantime, steps were initiated to ascertain the actual loss suffered by the families on account of damage of homestead granary animal by the revenue and forest officials. As per the damage assessment report, the loss was estimated between the range of 50 to 2 lakhs. We fully agree, lordship. This is our findings.
What we are saying.
But the case is not here. The case here is that you have given 10 to 50,000 to a particular category. So enhance us, we receive 10,000.
Hmm.
Had it been a case that 10,000 is a meager amount, we want 2 lakhs rupees. That case
You-
would have been different.
You have made this is your own assessment.
Our own
But the
assessment,
damages-
but at the same time,
Yes,
government cannot.
The finding is that the state failed to protect these people. That was the
I
obligation
fully
of
agree,
the,
lordship, but that is not the cause of action of this writ petition.
why?
The cause of action here is that as
That you have given 50,000,
50,000 to
Right.
those land,
bring it on parity. That's what their argument is.
their argument is, but we have a reasonable classification.
Okay, very well.
The reasonable classification is that, lordship, they immediately went back to their home.
That we understand,
They have their own land and property. For controlling their damage or to overcome the damage, immediately amount was given to them.
Where is the report of the committee?
Report of the committee.
What the committee has recommended?
A report.
And
of the
how have
committee-
you dealt with that report?
That report is not, I'm not sure it is in the record, but
Where are
that
5?
that impugned order
Where are 5, please?
by the
Whether
notification.
that order also takes into account this
Yes,
report of the committee.
after that, they came to the court and the honorable court directed that give them 10,000 rupees. To all of them. May I read it?
There is a report of a committee constituted by the government.
Constituted by the government and government was not paying thereafter. Then they came to the honorable court.
Read the recommendation, please.
By notification dated 2/4/2007, the government of Assam had constituted an 8-member committee with the departmental minister as the chairperson to examine and recommend in the matter of finding a permanent solution for rehabilitation of the families affected during the ethnic violence of 93, 96, and 98. The said committee recommended payment of 50% to each of the families dwelling in the relief camp, and such recommendation was translated into action by the government with the sanction of necessary fund to cover 7,951 families.
Hmm.
In pursuance thereof, a money was paid to the inmates of 2 camps, Joypur and so and so. 8 to 7,951 to calculate.
So do we have that report, please?
10,000. Although the affected party of the petitioners had moved out of the relief camp prior to receipt of the ex
So this
gratia-
this is in reference to the earlier round of litigation.
Yes, lordship.
What is that report? Can we have a look at it? And whether your speaking order
Speaking
Deals
order
with
which
that
I have
report.
placed,
deals with
31/3/20,
deals,
54.
whether it deals with that report. The recommendation of your committee. At least that can be expected, that the committee which you have constituted,
Mhm.
you will, if you take a different view, At least that report has to be dealt with.
Page 37, Lordship, one of the meeting, minutes of the meeting.
Let's see, let's see. 37.
Minutes of the second meeting of the General Committee for the Society for Rehabilitation of Violence Affected Families in the Relief Camp of Bongaigaon held on 27th May 2009 in the conference hall of the Chief Minister.
Hmm.
Discussion and future course of action. The committee unanimously felt that judging from the response to the advertisement for purchase of land issued by the society, it is unlikely that adequate land would be available for settlement of all families living in the relief camp. Further, the resistance by local people to the settlement of these families outside Bongaigaon and Kokrajhar district cannot be ruled out. The representative of the camp inmates also expressed the view that their settlement after purchase of land by the society would be a long-drawn process. In view of these factors, the representatives of the camp inmates requested for one-time lump sum financial assistance to each of the family as full and final rehabilitation grant. They assured that after receipt of the financial assistance, the camp inmates will find land for themselves and vacate the camp.
This doesn't even take into account the people who had suffered the losses in the violence. That was the earlier report.
Lordship,
That's why the earlier report is relevant.
here the whole case is that why you gave us 10,000 and not 50,000, you gave 50,000 to others. That is the core issue here.
Right.
If Lordship wants to expand it, then I can come bring. all
Not an expansion. We want to know what was the recommendation earlier.
Of the first.
The committee which you formed, 2007.
It's a Nigama report. Let me check.
To find out that committee report,
Yes.
Advocate General shall keep the report of the 8-member committee constituted by virtue of notification dated 2/4/2007 on record. List on next Tuesday.
Lordship, yes, Lordship. Or could it be after 12th of June? Lordship?
Very well. 13 June,
13th. 14 June, Lordship.
14 June, 15 June, that will come over. Hearing day, 15.
And I'll also bring all the other litigations orders, Lordship.
Please do that.
Yes,
Please
sir.
do that.
Highly obliged.
Item number 7.
Yes, please, Lordship. Lordship, due to the medical problems of my senior's wife, my lord, he could not come today, my lord. I'm saying that it will be fixed after a week, my lord.
That was the request on 9th May also.
Yes, my lord.
What is the matter, Mr. Botakur?
Lordship, this matter also relates to selection of a principal, Your Lordship. My selection was challenged, Your Lordship. That was, the petition was dismissed.
And what has resulted thereafter? Your client is holding the post.
No, Your Lordship.
Why? There's a stay.
There's a stay order from this one.
You are enjoying a stay, sir. That's not fair. And we'll discontinue the stay then.
Well, let my senior may come, my lord. Actually, due to the problem of my senior's wife, he could not come today, my lord.
Tuesday,
Okay.
Lord,
list on. Since 2019, you are enjoying stay. Thirtieth June.
Item number 9 to 11.
Who is it?
For the time.
Which time of the month?
Lordship, item number 9 to 11 may be taken after some time, Your
All
Lordship.
right, pass it. Pass it.
All right.
Item number 12.
Yes.
May I please, your Lordships? Also, item 12 is a petition under, we are essentially assailing the third borough accord, which was signed between the government of India, government of Assam, and certain stakeholders. We are challenging its validity and the subsequent actions taken under it, which also is a subject matter of challenge. Now, if Lordship will kindly come straight to page 3 of my synopsis, we have consolidated the reasons for approaching this honorable prayer. Para 2, Lordships.
Just. Synopsis. Page 3 or para 3?
Para 2,
Writ petition is being filed.
no, I am referring to the synopsis, Lordship.
Yes, we are reading
Page
the
3 of the synopsis.
Yes.
Para 2.
There is no pagination, but yes, para
I'm
2
sorry,
is,
actually, I also noted it.
no issues, no issues.
I'm so sorry.
We are with para 2.
Yes,
We are at para 2.
yes. So
Read,
we have consolidated the issues.
read.
This writ petition has been filed.
What is
because
the locus of the petitioner to
Yes.
file this?
Yes, Lordship. We have explained that at para 5.
All right, read
Yes, para 5 of at page 38
of your writ petition.
of the writ petition.
All right, let's see that first.
Yes. May I read it, Lordship?
Yes, yes.
That some of the petitioners herein had earlier filed WPC 996 of 2021 under Article 32 of the Constitution before the Honorable Supreme Court, praying for similar relief. The Honorable Court, by its order dated 8/10/2021, was pleased to permit the petitioners.
Can we have a look at that order, please?
Yes, that order is at page 203, Annex 13. In fact, I had appeared there also before the Supreme Court.
Yes.
And thereafter, Lordships, on the aspect of locus, would Lordships kindly see the subsequent paragraph? The petitioner number 1 is a Sahitya Academy recognized non-political organization that was formed on 17th March 1985 with the aim and objective to give scope for literary works to the Boro writers and create new writers among the Boro communities. The petitioner number 2 is one of the signatories to the first Boro Accord signed in 1993. He was also a 4-time elected member of parliament. The petition number 3 has been a 3-term cabinet minister in Assam government and also one of the signatories of the second Boro Accord. The petition number 4 is the former deputy chief of the Boroland Territorial Council from 2003 to 2020 and also one of the signatories of the second Boro Accord.
All right. Yes.
The petitioners number 5 to 9 are all public spirited persons and signatories to the second Boro Accord. The petitioner number 10 to 95 are vigilant, public spirited and conscious citizens of India residing in BTC. As such, they are entitled to all rights and privileges protections guaranteed to the citizens of India under the Constitution and the laws framed thereunder. So this is how we have explained our locus to file this petition, Lordships.
Okay. And what is the challenge precisely?
Now, if your Lordships come to back to the para 2,
All right.
where we have consolidated the issues that calls for adjudication in this writ petition.
Yes.
The writ petition is being filed because of certain issues relating to the rights of Boros, which are recognized and guaranteed by peace accords, as well as the Constitution, have now been thought to be taken away. This has been done by executive orders, which directly and substantially affects the rights of people and is contrary to the law laid down by this Honorable Court in Rai Sahib versus the state of Punjab, and that fundamental rights cannot be taken away by executive orders alone. In particular, in this case, the rights of constitutional autonomy and culture are violated, being contrary to the provisions of the 6th schedule of the Constitution and the second Boro Accord signed in 2003. From the attending facts, it does transpire that such rights which inhere in the Boro people and in the Boro territories are being gradually clipped Act to take away the very autonomy which was guaranteed by the Second Borough Accord and the constitutional dispensation. Certain offending clauses of the tripartite memorandum of settlement, that is the Third Borough Accord signed on 27 January 2020, is being assailed, which are extracted herein for ready reference. So these are the clauses that we, and why the challenge on the ground, Lordship, I'll take Lordship to that. Now, Lordship, before I proceed further, it is necessary for me to give a historical perspective as to how this accord has finally culminated. Now, initially, Lordships, we see that this was a region which has admittedly seen a lot of violence, and therefore there was concerted effort by the government to settle the issues, the aspirations of the Boro people. The first accord that came to be signed was in 1993. We have given that, I'm just orally submitting. And thereafter, since the 1993 agreement did not meet its desired results, a need was felt to revisit the issue. And then came the 2003 accord, which is the accord which we say is now being violated by the recent accord. Now, would Lordships first see the terms of the 2003 accord? What did it envisage? What did it give the people? Because it is important to note that the 2003 accord was followed by a constitutional amendment, giving it a constitutional recognition under the 6th schedule. So therefore, it had a constitutional recognition to the accord. So would Lordships first see what was envisaged in the 2003 accord, which we say has served this purpose.
All right.
Now, would Lordships first see the Second Borough Accord, which is Annexure P1, page 131.
February 2003.
Yes, Lordships.
Yes.
The petitioners before your Lordships, several of them are signatories to this accord.
All right.
Bishop. Memorandum of Settlement on Boro Territorial Council, New Delhi, 10th February 2003. The Government of India and the Government of Assam have been making concerted efforts to fulfill the aspirations of the Boro people relating to their cultural identity, language, education, and economic development. Towards this end, a series of talks were held between the Government of India, Government of Assam, and the Boro Liberation Tigers since March 2000. As a result, it is agreed to create a self-governing body for the Boro areas in the state of Assam as follows. Objectives, Lordships. Now, this is very important, Lordship. I'll request Lordships to mark that sentence. The objectives of the agreement are to create an autonomous, self-governing body to be known as the Boro Territorial Council within the state of Assam. So what is necessary to be noted is it's an autonomous, self-governing body. The idea was to give them autonomy within the framework of the Constitution and to provide constitutional protection under 6th schedule to the state autonomous body to fulfill economic, educational, and linguistic aspirations and preservation of land rights, socio-culture, and ethnic identity of the Boros, and to speed up infrastructure development in BTC area. This was precisely the objective. Now, the next para that Lordship would kindly have a look is at para 3. What was the area that was earmarked in this agreement? The area of proposed BTC shall comprise of 3,082 villages and areas to be so notified by the state government. The above mentioned villages and areas shall be divided into 4 contiguous districts after reorganization of the existing districts of Assam within a period of 6 months of signing of the agreement on the lines of the proposal given by BLT, subject to clearance of the Delimitation Commission. So if I may just pause here for a moment, the fact of 3,082 villages now crystallized.
Okay.
There could not have been any tinkering with that. The only tinkering was provided in 3.2. A committee comprising of 1 representative, each from the Government of India and Assam and BLT, will decide by consensus on the inclusion of additional villages and areas in the BT3 out of the 95 villages and areas on the basis of criteria of tribal population being not less than 50%, contiguity or any other agreed relevant criteria within the period of 3 months of signing the MOS. So therefore, Lordships, the idea of this accord was The 3082 village is crystallized. Out of the 95 where there was a certain dispute, a committee would be set up to either include them into the area or not, or keep them away. What this present accord has sought to do is to tinker with the area itself, which I will show, Lordship, that they are now talking about exclusion of villages from that area. So therefore, as per this accord, there was no question of exclusion of any villages as is being sought by the latest accord. Lordship will kindly mark that portion. Now, having seen this, please come. Then, of course, this accord sets down the powers. Now, this accord was followed by a constitutional amendment. Would Lordships come to page 138, which is the statement of objects and reasons of the strict schedule. But this was a statement and objects and reasons for bringing in the amendment. What was the idea? May I place it, Lordships?
Yes.
The provisions of the strict schedule of the Constitution have evolved a separate scheme for the governance of tribal areas in the states of Assam, Meghalaya, Mizoram, and Tripura through the district councils or regional councils. There are 3 parts in the table appended to the schedule. They are so divided in order to distinguish the areas. The area in part 1 represent the tribal areas of Assam. Each of these areas constitute an autonomous district. The provisions of paragraph 1 to 17 of the strict schedule relate to administration of these autonomous districts. The councils are vested with legislative powers on specified subjects and are allotted sources of taxation. They have also been given powers to set up and administer the system of justice and maintain administrative and welfare services in respect of land, revenue, forest, education, public health, etc. The Boro Accord was signed on 20th February 20, 1993 with the All Boro Students Union and the Boro People's Action Committee with the objective to provide maximum autonomy to the Boros within the framework of the Constitution for the social, economic, educational, and cultural advancement. In pursuance to the Boro Accord, an interim Boroland Autonomous Council was constituted by the government of Assam by enacting state legislation. Boro groups were of the view that Boro Accord had become unworkable due to non-implementation of the accord in letter and spirit. Based on the tripartite talks, a memorandum of settlement has been signed between the central government, the government of Assam, and the Boro Liberation Tigers on 10/2/2003 for a durable solution to the Boro issue. I may just pause here for a lot. The Boro Liberation Tigers, if I may just let your lordship know, was the spearhead of that movement. So therefore, they were considered as the stakeholders of the entire community. So that is why they were the party. To meet the aspiration of the Boros in Assam and in pursuance of the memorandum of settlement, it is proposed to create an autonomous self-governing body to be known as the Boroland Territorial Council within the state of Assam, which shall have the legislative, administrative, and financial powers in respect of specified subjects. Provide for an adequate safeguard for non-tribals in the BTC area to ensure that they are not put to any disadvantage in relation to any rights and privileges, including land rights presently enjoyed by them at the commencement of BTC. The bill seeks to achieve the above objects. And then, Lordship, of course, the constitutional amendment follows, which is at page 140, is where the constitutional amendment follows, and subsequently it is incorporated. So having under these circumstances, subsequent to the constitutional amendment, a OM came to be issued by the government to draw out how the BTC and the state shall function, what are the subjects that are being given. Because in fact, this constitutional amendment, if Lordship will see at page 141 of the amendment, of the Act, after I am at para 5, after para 3A, the following paragraph shall be inserted. Additional powers, 3B, that is additional power of Boro Territorial Council to make laws. So under this, 39 subjects were transferred to the BTC. And these are the 39 subjects that are laid down here. So these 39 subjects were transferred to the BTC. Now, post this amendment, Lordship will come to Annexure 3 at page 146. A very crucial annexure. 16th October 2004,
Page 143,
146, Lordship.
6, yes,
146, Annexure 3.
OM. yes.
OM, Lord. This is 16th October 2004. Whereas in pursuance to the memorandum of settlement reached between the government of Assam, government of India and BLT on 10th February 2003, which I have shown to your lordship, in New Delhi, in presence of the Deputy Prime Minister of India, it has been agreed to create a Boro Territorial Council within the framework of the amended 6th schedule of the Constitution, and whereas the government of Assam, by notification dated 31st October 2003, adopted and approved the aforesaid MOS and resolved to extend executive powers to the 40 subjects departments listed in Annexure 3 of the MOS. Whereas the governor of Assam has been pleased to entrust the delegate and functions relating to 39 subjects departments, excluding Relief and Rehabilitation Department listed in para 3B of the 6th schedule as amended of the Constitution, and to which the executive powers of the state extends. Now, therefore, following the administrative procedure and modalities are framed by the state government in consultation with the Boro Territorial Council for the purpose of day-to-day administration in respect of the 39 subjects departments, excluding Relief and Rehabilitation referred to above. Now, I am not taking your lordships to every clause of this. What is relevant for the purpose of adjudication, would lordships will kindly come to page 149. What was the powers given to the BTC and how it is now being taken away? Clause G at page 149. May I place it, lordship? The BTC shall have full control over the officers and staff connected with the entrusted subjects working in the BTC area and shall be competent to transfer these officers and staff within the BTC area. ACRs of these officers shall also be written by the appropriate BTC authority. Then lordship will see H. BTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the government of Assam.
Yes,
The council shall constitute a selection board
yes,
May I proceed, Lord? BTC shall be competent to make appointment on all posts under its control in accordance with the rules of appointment followed prescribed by the government of Assam. The council shall constitute a selection board for appointment to be made by it and shall also make rules with the approval of government of Assam to regulate appointments. All circular relating to filling up of vacancies and appointments issued by the government of Assam from time to time shall be followed fully. However, the posts where recruitment will be made on recommendation of APSC shall not be covered under this provision. Then lordships will kindly come to clause L at page, very vital for financial autonomy. What was the extent of autonomy given? 151 page clause L. The Bodoland Territorial Council shall prepare the estimate of receipt and expenditure pertaining to Bodoland Territorial Council in respect of the entrusted subjects departments as per the allocation norm, etc., communicated by the state government. The Bodoland Territorial Council in their council session shall consider the estimated receipts and expenditure pertaining to Bodoland Territorial Council in respect of the entrusted subject departments and send the same along with the synopsis for consideration to the state government within the stipulated time as provided for in paragraph 13 of the 6th schedule of the Constitution. Ordinarily, very important, ordinarily no change will be made in the estimated receipts and expenditure as considered by the Bodoland Territorial Council in respect of the entrusted subjects departments. However, for any reason, if it becomes necessary to do so, The council shall be consulted and reasons for the proposed changes will be explained.
Yes.
The state government then shall then place the estimated receipts and expenditures as considered by the Board and Territorial Council, along with the synopsis before the state legislature as provided for in para 13 of the sixth schedule of the Constitution. Next clause M. Bodoland Territorial Council Authority shall prepare a plan with the amounts likely to be made available for the developmental works, both under a state share and the central share, covering any or all the activities of the departments under their control. The council shall have full discretion in selecting the activities and choosing the amount for the investment under the same in any year. This plan will be a subset of the state plan and will be treated as its integral part. Once the plan of the state, including BTC plan, gets the approval of the Planning Commission, the BTC authority shall start executing of their plans in the BTC area. Modification, if any, made by the Planning Commission in the BTC proposal shall be binding on the BTC authority. BTC shall have a planning department to prepare the plans for BTC area to be submitted to the Planning Commission to the Government of Assam. Now, next clause, Lordships, clause N. All centrally sponsored schemes, all centrally sponsored schemes, central sector schemes, NEC schemes, externally aided schemes, etc., in respect. May I be permitted to, after reading this, may I be permitted to be led?
You're doing fine.
Very good. Very good. In case I get.
He won't be minding getting that respite. He's otherwise also overburdened. Give him some rest.
Very well.
Carry on, carry on.
Well,
We'll see if required.
yes.
We'll allow this.
Yes. All centrally sponsored schemes, central sector schemes, NEC schemes, externally aided schemes, etc., in respect of the entrusted subject departments, for which fund will be released by the state government to the council as per sanction and released by the Government of India to the state government, shall be implemented by the council as per norms and guidelines of the Government of India and the state government. Now, I will just pause here for a moment. So this OM would make it very clear that the BTC has been given, a large scale autonomy in respect of its financial matters, in respect of posting officers, as we see, in respect of the services and the finances of the BTC. Now, having seen this, now this is followed by the accord that we now impugn, which is Lordships at Annexure 4, impugn third accord. Lordship, it is at page 155.
Yes.
We assail this and the consequent action that has been taken ostensibly by virtue of the clauses in this accord.
This is, the heading is memorandum of settlement.
Yes, memorandum.
Between whom?
MOS.
Between whom?
Between the Government of India, Government of Assam, and
BTC.
BTC.
Hmm.
Now, if Lordships will see, the signatories are at page 159.
Okay.
It is the General Secretary, All Borough Students Union, the President, All Borough Students Union. And this is Ranjan Daimeri.
NDFB, what is NDFB?
One faction,
Oh, the faction, all right.
faction, then President UBPO, and of course, the Government of Assam and the Government of India. And, no, he's a witness. Agrama is a witness. Now, may I place this accord? Standing upward.
Yes,
May I place this lordship?
sure.
The government of India, government of Assam have been making concerted efforts to fulfill the political, economic, social and cultural and identity-related aspirations of Boro people. Tripartite agreements in 1993 and 2003. which we have
Before we
seen.
proceed further, Ms. Council,
Lordship,
you are operating under the amendment as made by the Constitution
yes, sir.
from 2004 till 2020.
Yes, sir.
Do we have a schedule of what development works have been carried out in the council in this period? This period of 16 years. Can you please,
I don't have it immediately, Lordship. but
we'll like to have a look at it.
Certainly.
There is a reason why we are asking this question. We have seen a similar kind of activity in some other case. So we just want to find out how this accord benefited the area.
How it
That's
works
for-
itself out,
Yes,
how it works itself out.
how it worked out.
Okay, very
That's
well,
what we want to know.
very well, Lordship.
So what will you place on record? Has there been any documentation of what works have been carried out? What progress has been made in the areas assigned to the council under the sixth schedule? What is the precise status, utilization of funds, developments, recruitments? Can you please give out some summary of these to us?
Well, Lordship, ideally, now the petitioners are not the elected representatives.
Maybe these things will be available.
By,
This is a PIL, so we can ask you to make research and present the things to us.
yeah, but ideally, the BTC is also a party here. We have made them a party.
Mhm.
So if that, because the records would, I'm just speculating, I may
Yes,
be
of
wrong.
course.
I may be wrong, but the records would be with them.
Mhm.
So they can perhaps place.
As an adversary, let us know, you tell us what has been the development during this period.
Uh,
You're trying to retrace the things back as they were under the accord and as under the constitutional amendment. You said that this is an impeachment, a infringement into the constitutional scheme.
Yes, Lordship.
So let us know how the things worked out after the original plan of giving autonomy to the council.
Well, that would be a very relevant consideration.
Yes. Because the state, when it is going through this settlement, it must have realized over a period of year, the experience, how the things, and the union, of course, how the things have worked out. So the things are dynamic, they don't remain static. There's a new kind of concept, which the result whereof has to be tested with time. So after being tested, what is the consequence? Let us have an idea of that.
We'll file an affidavit to that effect.
Do that,
But
please.
Lordship will also then, at the same time, Lordship will also have to perhaps determine the issue
Yes.
that when accord has, I wouldn't
We
say
will
that
of course go into that. This question we are posing, because we probably see that the reason of this deviation, as you say, might be the result of the experience over a period of 16 years.
could be.
So let's have a look at that.
Very good. We'll file an-
When will you be able to file it?
May I just take instruction?
Sure. Take. You take your time, you come back to the court after 10 minutes
Very good.
and let us know.
But I would just request that we will put in an effort. If the BTC authority can also.
We'll ask them also. We'll ask them.
Yes, because that
Yes.
would be then the whole picture.
We'll also ask the state of Assam to do that.
Yes, in fact, that will.
May it please your lordship, I had filed an impeachment application, your lordship, IA 1528/2022.
Implement application. Okay. It's on behalf of,
Hridoy 1528, your lordship. IA.
yes, who is the applicant?
Hridoy Fowler from BTC, your lordship, Hridoy Basumatari, Pudung Brahmo.
Have you got a copy?
Sunil
We have got a
Basumatari.
copy, but then I don't think so it is really necessary for them to be impleted, Lordship.
What do you want us to do of the application?
Ideally, Lordship, it is a Lordship's decision whether to allow, but we would like it. to be-
You have not filed any opposition.
No, we haven't.
So it is to be accepted. Are they be allowed to act as interveners or parties?
Intervenal, Lordship, at the most they can address the court.
All right. IA number 1528/22. This interlocutory application has been filed by applicants. 10 applicants seeking impediment as party respondents in the original petition number so and so. And counsel for the petitioners submits that though no formal application, no formal opposition has been filed to the application. However, he does not have any objection if the applicants are allowed to act as interveners in the matter. Thus, the application is disposed of, directing that the applicant shall be permitted to act as interveners in this said petition. Counsel for the petitioner shall place on record the details as below, so as to satisfy the court as to what has resulted after granting autonomy to the BTC under the accord dated so and so. Number one, status of development works undertaken during the period, major development works. Number two, the recruitments made on the subjects for which the BTC was given absolute authority. Number three, development will cover everything. The state of Assam shall also file an affidavit in this aspect. List.
My lord, for the present, we are taking 2 weeks' time. In case we can't, Lordship will kindly accommodate.
Oh, yes, sure. List on date, please. What
My
date?
lord may have it before vacation, my lord, once.
As you say, whenever you, 15 June,
My lord.
15 June.
Or let it be 16th, my lord.
No, we'll take it up on a hearing day. Thursday or Tuesday.
Okay, my
Vice Pro-
Or would it be inconvenient 22nd, my lord?
No issues, no issues. 22nd.
Deeply appreciated.
Deeply grateful. Lordships.
Deeply.
Matter number 14 and 15.
No tender, nothing. Pull up. Nice. Yeah, please. Yeah. You're not.
Before proceed to the matter,
Yes.
Lordship, may I pray, Lordship, this matter may be taken up any date in the next week because Mr. Senior Lordship, Senior Counsel, Mr. M. K. Chaudhary is appearing in this case. He is contesting in the election, Lordship.
That is a strong ground. Ms. M. K. Chaudhary, Senior Counsel representing the respondent, is not available to argue the matter today.
Tuesday.
List, not in a position to argue. List both these writ appeals up to 2 weeks for hearing up.
Can we have a shorter date, my lord?
When do you want?
My lord, there is an interim order operating, my lord, and already the board is constituted.
Mm.
And the person, my lord, who was declared not as per law appointed, he is running, man.
When do you want it?
My lord, it can be next week, my lord. Can it be on?
30th,
It's a Thursday, my lord,
8th, 8 June?
June.
My
8
lord.
June. I got to apply again.
Either 1st June or 8 June, whatever you say.
एक मिनट
First June, my lord. First of June.
Obliged.
Obliged, my lord.
1st June.
Matter number 18.
18, last. There are some passed over matters. Yes, please.
May it please your lordship, my lord. My lord, here the, my lord, date of correction of date of birth. My lord, the learned administrative tribunal has allowed. My lord, here, while the father of the petitioner alive, my lord, he made certain declaration, family declaration in the service book, my lord. Page 17 is the family declaration, my lord.
1/7.
1/7, my lord.
Yes, please. Change in date of birth of the employee,
No, my lord, this is son, my lord.
his son.
Yes. Well, the serial number 5 is the Barik Mia Chaudhary. He is the son. And the father expired in 2001, my lord.
Okay,
And while he was in service in 1994, he made the family declaration stating his son's age, date of birth as
92.
15/4/92.
Okay,
My lord, now, my lord, the son has filed application, page 33,
Hmm.
stating that his date of birth should be 15/4/1996. Malad,
so that, for that he has to go and file a civil suit. All the
my lord,
criminal has jurisdiction.
therefore, my lord. And that, and moreover, how the father will know, my lord?
So that is not a service dispute. It's not a service dispute. Not a relevant fact, sir. This Administrative Criminals Act.
My lord, after 2 years, my lord, how the father will know before 2 years his son will born, my lord. So on this count itself, my lord. And moreover, my lord.
Yes.
Some judgments are there,
Premonition.
my lord. Even if certain proof will been shown afterwards, my lord, there.
Otherwise
may be for the
also
Future use.
This remedy
Yes,
of getting a change in date of birth
yes.
of a family member.
Yes.
How is the subject matter of dispute before the tribunal?
Exactly, my lord, correct,
He
my
has to
lord.
file a suit.
Correct, my lord. And therefore, there is a
Yes.
difference,
Mm.
different note, my lord.
It's immaterial, sir. Otherwise, even if it has been remanded, it is a wrong order of remand.
My lord, therefore, my administrative member, my lord, he deferred this. My lord, kindly see page 80.
Just hold on.
Yes, ma'am.
Read section 15, sir. How does tribunal have jurisdiction?
Section 15 of the
Administrative Criminals Act. You don't have it?
a bit right. I'll go.
They're not.
May I read your lordship?
Read for yourself. We have read it more than once. Try to tell us under which clause of 15 your dispute comes so as to entitle the CAT to entertain your original application.
Lordship, what happened? Actually, initially, we have approached this honorable court, your lordship.
Yes,
And this honorable court directed that we should approach the honorable CAT for redressal of the grievance.
maybe it was a wrong direction. The CAT has no jurisdiction. This court could not have decided what the jurisdiction of CAT is.
So matter was remanded to the CAT at the.
It was not remanded.
Lordship,
it was not
kindly-
remanded.
kindly see the
Liberty is given to you.
debate, yes.
You should have said, no, sir, I don't want to go. It's a civil suit which I have to file. Tell us, sir, please, plain and simple.
Lordship.
Under what clause of section 15? And 3Q.
May I read the order of this honorable court for a moment, your lordship?
We have
Last
read
order.
it. We have read it, gentlemen.
They have not annexed it, but it is in the original
No,
OA.
it's there at page 59.
Lordship.
It's an erroneous observation, plain and simple. The court probably failed to realize that the dispute was being raised by the son of the employee, not the employee himself.
Even they have not took up this.
We are
Defense
asking you,
before the-
gentlemen, we are asking you. This court is exercising 2 to 6. In the jurisdiction of the
At no
authority which
point of
passes
time,
the order.
the respondent authorities has raised this issue that it is not.
You want time to respond, we can give it. But the writing is on the wall. His service, his service. This is not his service. It's a son trying to rake up an issue which is a dead horse. You still have a chance of taking liberty, file a civil suit if you want.
I can go, your lordship, but I have already agitated for last 3-4 years before the CAT, then before this honorable court also.
All right, then argue on this. What jurisdiction the cat had. This court could not have conferred jurisdiction on the cat. This court just gave you liberty. This court did not prohibit you from approaching the civil court.
The lordship, this honorable court has referred to section 3Q,
Yes, read that also, please.
lordship. Service matters.
Relating to the conditions of his service. This is not a condition of the service of the employee. You read it 10 times. There is no remedy before CAT. Change of date of birth of the employee maybe. Even that would not be the domain of the CAT. There has to be a civil suit.
Even widows are coming before the CAT for getting pensionary benefits, and it has been entertained.
Pensionary benefits.
It is also,
This is plain and simple change of date of birth.
it also relates to pensionary benefits. your lordship.
All right, then we remove that part. So
Minor,
change of birth is not domain of CAT. Then what happens? What is the primary prayer? What is the declaration?
Correct the date of birth.
correct the date of birth and grant the pensionary benefits
So-
as is.
After correct.
And lordship, date of birth, we are arguing on the basis of the documents issued by competent authorities.
Forget that, sir. Who is the competent forum? You read section 15. Tell us under which clause of 15 your dispute comes.
40, section 14.
Yes, read.
Save as otherwise expressly provided in this act, the Central Administrative Tribunal shall exercise on and from the appointed day all the jurisdiction powers and authority exercisable immediately before that day by all the courts except the Supreme Court in relation to recruitment and matters concerning to recruitment to any All India service
or to any civil service of the union or a civil post under the union or to a post connected with the defense or in the defense services, being in either case a post filed by a civilian, filled by a civilian. Number B, all service matters concerning a members of any All India service, a person not being a member of All India service or a person referred to in clause C, appointed to any civil service of the union or any civil post under the union, or a civilian not being a member of any All India service or a person referred to in clause C, appointed to any defense service or a post connected with defense, and pertaining to the service of such member, person or civilian in connection.
The focus is on such person, the person who is or was in service. Your relief of pension is an ancillary relief.
Right.
Your main relief before the tribunal was change of date of birth, which the tribunal does not have any jurisdiction.
It will take some time. And I'll come back.
Nothing to see, nothing to see.
So generally, these types of cases are being admitted
Come at
by our, not sure any other day, Lordship. I'll go through it.
Tomorrow,
Next week,
tomorrow,
Monday, your Lordship.
Monday. Monday, top of the list.
Oblige, Lordship. Monday. No, because this issue, since there was no objection, I have also not considered.
Gentlemen, there is no need of any objection. This is fundamental question.
Lordship is
We
correct.
didn't even open the second thing.
But this
We
matter,
just put this proposition, change of date of birth of the son. The next question is quite terminal. The moment the phrase change of date of birth comes, the civil court comes. और कहीं ढूंढने की जरूरत नहीं.
oblige, Lordship.
Okay.
Item number 9 to 11, passed over matter.
Then Guwahati High Court lawyers will be thinking, Chief Justice is too hyper technical. But it's a fact. Jurisdiction parts have to be adhered to strictly. You can't just widen the scope. Yes, Mr. Chair.
Lordship, this appealed by the department against the order of the CCAT on 16 to 23. Lordship has framed three questions of law.
Yes.
First was whether the CCAT Calcutta erred in law in holding that the standard of proof as embassies under section 123 of Custom Act is the test beyond reasonable doubt. Second was whether the CCAT Calcutta has erred in law setting it the order of confiscation when seized goods were found to be unfit for human consumption as per test report of Export Inspect Agency Calcutta under the Food and Standard Regulation 2022. Third was whether the finding of the CCAT Calcutta are perverts under the present facts and circumstances of the case. I want to take to your Lordship the order in original at page 12. In this case, areca nuts were seized.
Betel nuts.
Betel nuts that were found to be of foreign origin. Lordship.
Of foreign
Foreign
origin. Okay.
Imported from Myanmar without having any documents. That was the
Okay.
basic case of the department.
Hmm.
Lordship may come to page 103, facts of the case.
Just.
Although order is very long, but I'll take to Lordship some particular paragraph. here.
Yes. Yes.
Married Lordship.
Mhm.
Paragraph 1, acting on the an intelligence to the effect that huge quantity of smuggled betel nut were stored in a around Mehrabari and Ramanathpur area of Assam Mizoram border and were supposed to be transmitted to the officers of the Director of Revenue Intelligence, Silchar Regional Unit, Silchar, along with DRI Aizawl Unit, Aizawl and Custom Division, Aizawl, on 1/7/2018, searched a godown, but nothing incriminating was recovered. On suspicion, they checked two stationary truck being registration number so and so near Barabari railway station crossing area. Both the vehicles were found to be loaded with betel nuts. On query, the driver of the said two trucks neither could produce any document nor give any satisfactory reply regarding the goods loaded in the truck. On preliminary checking, the goods were suspected to be of smuggled nature and therefore the said two trucks were detained temporarily at place of interception.
Yes.
On further information, the officer detected three more betel nut parent trucks bearing registration number so and so at the hilltop of Ramnathpur area, which were intercepted and detained temporarily in two of the above mentioned trucks bearing registration number so and so. Only the helper were found, but the truck number so and so was found to be bereft of any occupant. On one of the helper of the truck informed that the driver had gone to Ramnathpur police station to show the documents of the truck and the goods. The officer went to the Ramnathpur police station to locate and identify the missing drivers, but the driver could not be found. The officer met officer in charge of the Ramnath police station and inquired about the drivers, but without any success. The officer searched around looking.
Come to the relevant part, Mr. K.
Lordship,
Trucks were stopped, there were no documents,
Lordship,
then what? What is the basis of
page-
determining the fact that they were imported or they were smuggled?
Lordship,
They didn't have any identification marks.
yes,
बर्मा का सुपारी और असम का सुपारी में फर्क होता है क्या कुछ?
yes, Lord.
दिखने में?
Yes, Lordship, these are the big in nature, the Myanmar suparis. And Assam suparis are small in nature.
Small in size, not in
Yes,
nature.
So, Lord, I'm sorry, this is in size. It can be identified by bare,
Is that
size,
the
Lord.
finding?
Lordship, no, Lordship,
Then come to the finding, please.
Lordship.
What is the basis of the finding that they were smuggled from Burma?
I'm coming, Lordship.
Maybe some of the Assam cultivators may have given extra urea,
No,
so
no,
their
Lordship.
betel nuts grew bigger.
Lordship, the fact that they said that it was,
That was on the lighter vein. Tell us the finding, please. Read the finding.
I'm coming to Lordship. Page 167, Lordship. Paragraph 18, Lordship. 88.
167. It's a very long order.
Yes, Lordship, it's a very long order.
Yes. The drivers didn't give out anything which could indicate that it was smuggled goods. They said that it had been loaded
Yes,
from the railway station Verbi.
tribunal filing is very, this Lordship, only the tribunal said that under 123 presumption cannot be granted because this is not a notified goods. Lord. That was the finding of the tribunal.
So you will have extra burden or
Yes,
bigger onus to prove.
yes, Lord.
Let's see how you proved it.
Lordship, paragraph 88.
Yes.
Page 167. I have carefully gone through the case record and submission made by the noticee, both written and verbal. The case before me is that the officer of the DRI Silchar, while returning from the search operation, intercepted and detained 7 trucks laden with the betel nuts suspect to be foreign origin.
Where is the detention memo?
Lordship,
Where is the detention memo?
Lordship, for that record is
It's not there. All right, carry on. Yes.
the trucks bearing registration number so and so were detained near Bhairabari. Lordship, may skip this.
Hmm.
Lordship, middle part. The betel nuts were weighted and representative samples were drawn. As none of the driver, helper of the truck and the caretaker owner of the goods could produce any document in support of the legal importation of the recovered betel nuts believed to be foreign origin, the DRI officers.
The finding is that because they could not produce documents,
No,
so presumed to be of foreign origin.
Lordship, no, there was no document. And Lordship, interestingly, in Mizoram, there is no production of betel nuts, Lordship.
Maybe
They were.
they imported it from Assam and then they were bringing it back.
No, Lordship,
What prevents you? That can't be a ground.
no, Lordship.
Your conclusion is based on what?
Lordship, may-
Only conclusion is no documents produced.
90, Lordship, paragraph 91.4,
Yes.
paragraph page 170.
First read on this 88. As none of the drivers,
Lordship,
helpers
I'm-
could produce any documents in support of legal importation. So
the
legal importation means what? They never said that the goods were imported or smuggled.
Nobody was there to produce any document before the authority, Lordship.
Are they such goods? The possession whereof is an offense under the Customs Act.
Lordship, if it is found to be foreign origin, then they cannot.
Mere possession.
Mere possession
It's
is
not gold, it's not silver.
No, it is not notified.
So it's not that. Then,
The burden is on the
Department.
Yes, Lordship,
so now let's see how you discharge that burden.
Lordship. Lordship, paragraph 91.4, page 170.
Yes,
Therefore, it is evident that 11,390 cases of betel nuts.
para 91.3.
90, I find none of the above 4 persons charged in respect of the seizure of betel nuts made from truck number so and so have thrown any light on the actual honor of the betel nut or nature of the origin of betel nuts. Sri so and so, so and so, so and so.
Were they required to? Were they required to give out this
Lordship,
proof?
initial burden is on them to
In
produce the
case of betel
document.
nuts, we are not talking of prohibited goods.
No, that is, Lordship, that is the
123, yes.
Lordship, in that paragraph, further part, Lordship.
Let's
Sri
split up the paragraph. First finding, initial finding is wrong, is it not?
Lordship,
Because they could not give out the actual owner of the betel nuts or origin. Therefore, I presume it to be of foreign origin.
Lordship, the betel nuts of the foreign origin, whereas Sri as and so driver of the truck.
Where is the conclusion that the betel nuts were of foreign origin? What is the basis of that finding?
Lordship,
You record it in para 91.3 on what basis? So there is already a predetermination on part of the customs officer. Adjudicating authority is going with a predetermined mind. These are foreign goods. Read para 91.3. Even before the issue is determined, he writes,
their explanation that given that the truck temporary storage appears to be concocted, this is not backed by any evidence. They supplied the name of one of so-called manager of Psycho, alias Alam, who could not be apprehended. Further, the claim of Sri Dingthang that the betel nuts belong to one Srimati Sangeti of Champai could not be verified. Therefore, it was evident that Sri Isak Chava so and so were in position of transporting betel nuts of foreign origin, but were apprehended.
so Ms. KL, where is the conclusion that I am satisfied that these are foreign origin betel nuts?
Lordship.
Where is that conclusion?
Yes, sir. Lordship, page 174, paragraph 92.7.
Yes. 92.7.
Merit. From the above facts and statement of the noticee, the picture emerges is that the truck number so and so, which was loaded with 20 metric ton betel nuts, was intercepted while it was stationary at Ramnathpur. The driver Sri Naresh Chandra Burma has confessed that the said betel nuts were loaded in the truck from another 12-wheeler truck near Bhairavari railway station. Besides one go down at behest of
The betel nuts have been stated to be of Myanmar origin by test report of ARDF. All the authority of ARDF has been questioned by many courts of law. Trend of smuggling of Myanmar origin betel nuts, coupled with the facts and circumstances. There is no confession. None of the drivers or other persons inquired into says that it has been brought through that route.
They said it was loaded from another truck to their truck.
So what is wrong in that? Another truck standing in Myanmar? No.
No, it was in
India,
border area of
Mizoram,
Yes, sir.
border area. Even border area would not make any difference.
No, Lordship, I could understand the Lordship because heavy burden lies on the department. When there
It's a case probably,
these are not
it should have been a case for awarding compensation. For destruction of goods worth 72 lakhs.
No, we have not this. It is all this still it is
Still,
it is there. Lordship, as per
in what condition now?
No condition, Lordship, as per direction of this honorable court, that was tested before the authority, Lordship. That report is available before your Lordship. We said these are not fit for human consumption.
They became unfit because you detained it for years together.
No, Lordship,
Caesar was made when?
Lordship, please to see the initial.
Caesar was made in 2018. When was the test carried out?
It was in 2021 also.
So 3 years. Edible goods.
Lordship, report is of we have annexed.
Date.
216.
Date.
Date is 2018 probably. Lordship.
2018.
23/9/2018.
All right. Okay. So they were carrying betel nuts which were unfit for human consumption to use it as a fodder.
No,
Or
that is not their case, Lordship.
why are they required to? You are not prosecuting them under FSSAI.
No, we are.
No, you are not doing so. So they may carry rubbish in their trucks. Why you are bothered? Why the customs officers are bothered?
No, because it was foreign origin goods, Lordship. That's why the customs department is.
Gentlemen,
Is the.
that is why we asked you, where is the interception memo? Does it record that you have stopped the vehicles in suspicion of them carrying foreign origin
I
goods?
can produce the original record also, Lordship.
Read from this order. You complete your arguments.
Lordship, another finding
Yes.
is at page 176.
Hmm.
In view of the above, I come to conclusion that in respect of 20,390 kgs of betel nut, valued at rupees 51,17,000 seized from vehicle number so and so. Sapansa and Sri Naresh Chandra Burman have confessed to loaded the smuggled betel nuts on the roadside in their vehicle. Sri Roni Joliangura.
You come to 93.2. Goods were loaded at Champai, which has proximity to Indo-Myanmar border. This proximity issue was considered by Supreme Court in 1972, Rice Control Order, 5 kilometers. So the Supreme Court says there is no restriction. The truck can be turned back within that zone of 5 kilometers also.
Other fact is that there is no production in betel nuts in Mizoram, Lord.
But they took it for trading. They couldn't sell it, so they brought it back.
No, Lordship, if it is smuggled from Myanmar to India, Lordship, without having any document.
Gentlemen, we are asking you, how do you discharge the burden of proof?
That is, Lordship, when it is not notified.
It's not a notified goods.
It is not notified.
So how do you discharge that burden? What was the ground for you to intercept the vehicle at the first place? Does your officer say that we had reliable information? Does your order say?
That
You couldn't have stopped the vehicle. Your very search was illegal at the inception. Is it correct?
Lordship, this was a chance seizure, Lord.
No. No. Don't even think of it. Read the order first. It was not a chance seizure.
Because Lordship, they were returning from search and seizure from another. Lordship. That is what is reflected. from
Read
the-
page 103. So everything in pursuance of an intelligence.
On our further.
So where is that intelligence report? So you don't find anything in that area. You catch hold of poor two truck drivers who are carrying the betel nuts bona fide with bills and all other documents. They were having bills. It's your own case. GST.
Yes, Lordship.
Then how do you deal with that aspect about the GST invoices?
If, there were 6 trucks. Lordship, it is mentioned in paragraph.
Produce GST documents so and so. So how these were being transported? How your allegation
No,
that no documents were produced?
no, Lordship, obtaining GST documents, probably this will not result from that. There can be that e-wheel can be raised, Lordship, for transportation, Lordship. That is not mean that it is,
Is it your finding that these documents are forged?
Lordship, that I have not gone through that aspect of the matter.
Found in territory of India, no prohibited goods, information not placed on record. The goods were be accompanied by GST invoices. What was the ground to stop them? Let's read the order of the appellate authority.
Lordship, appellate order is at page 196. 196.
Yes.
Finding is that Lordship, finding page 204, paragraph 11.
Even the gunny bags were not having any foreign markings. Even the bags containing the betel nuts were not having any foreign markings.
That's it, the modus operandi of these persons to change the vehicle, change the all the bags and other.
You've got 108 with you up your sleeve. Why did you get that statement? That's a drastic draconian power given to the customs officers. All right, read the finding.
I find that the main issues to be decided by me in the instant case are as follows. One, whether the betel nuts seized by DRI silverware of foreign origin or not. Two, whether the appellant claim the ownership of the seized goods is tenable or not. Whether the seizure of the impound goods is legal or not. Whether the appellant was accepted the penalty imposed so. Now, paragraph 12. Now regarding the contention
That's
of
what
the
we
appellant,
said. Possession is not an offense.
123 of the Custom Act cast burden of proof on the department to establish that the goods were of foreign origin. Under section 123, the burden of proof lies on the party only in respect of gold, watches and other specified notified goods, and the burden of proof in all other cases shall lie with the department. The main contention of the appellant is that the areca nuts or betel nut not being not the goods falling under section 123, mere possession of the goods by them does not cast burden on them to prove that the goods were Indian origin or not for the foreign origin. The appellant on the basis contended that the department has failed to substantiate the conclusion that the goods were foreign origin. On that basis, the appellant had sought release of the goods confiscated by order in original.
Come to bottom 6 lines. The burden has been reversed by your authority.
Hence, the impugned cases, I find that the executing authority relies on the test report of the areca nut research and development, which clearly stated that the goods could have been of Myanmar origin, and also taken note the fact that none of the appellant, including those who have claimed ownership of the goods, were able to provide even contrary papers to prove that the goods.
This is the Commissioner appeals.
Yes, Commissioner appeals.
Yes. Then Sestet.
Sestet only dealt with 123 only.
Let's see. So what else was required to be dealt with?
10209.
Yes, read that. The Commissioner appeals is your mouthpiece. He knew very well that the department would be sued for damages in this case. That's why this order.
Let's see, after this reach, department is stop intercepting any truck, because this is the big problem. And since the repeated representation, government has not notified, and lots of huge, lots of.
Way out, Mr. KL, what we told you about that rice control order. In West Bengal, in the days when there was a drought, the rice control order was promulgated. So anyone found in possession of rice within 5 kilometers from the state boundary, there was a presumption of violating that order. But the Supreme Court went ahead and said, what is the guarantee that the vehicle can't be turned back?
Not that.
So you can bring out any this kind of notification.
And lots of
72 AI or Supreme Court. Yes.
And lots of recently, what happened? 25 trucks were seized by the state government. Ultimately, intervention of this one, that was handed over to DRI department for destruction. It was there were some anomalies by the department officer. Now, lots of 10 requests has been filed seeking compensation.
Yes, bound to be. And this is very shabby. This one.
Lots of huge smuggling is going on. Lots of.
You have to devise proper measures, scientific investigation. That's the only way out.
And lots of.
And we fail to understand. 108 is with you. In this case, there is not one confessional statement.
But statements are there, lots.
No one admits Myanmar.
No, that's that is there. And they will not admit to
And
that.
GST invoices are there.
Lots of.
GST invoices are there.
No, Lordship, that we can satisfy your Lordship, having GST invoice. And Lordship, in one case, just for reference, Lordship, they come for seizure was made in Mizoram. And all the bigs were the bags, as your Lordship stated, all they were making up, they're from Myanmar itself, Lordship. Then this honorable court dismissed the petition.
That's what we are, foreign markings.
Yes, that was.
Foreign markings is a different case.
And here the modus operandi is that they are in bakes on soldiers. They are taking goods from Myanmar to India and Lordship and packing in the. And the size of Myanmar supari is bigger than this is found in Assam. Lordship.
I know. You go to the holy tree. Rampant. Whole limestone. Then they file the cases. Yes.
Lordship, page 207, paragraph 15 of that appellate
Yes.
authority's order. Paragraph 15, Lordship, may I read it?
Yes.
Now I take up.
There are 6.
Of Lordship.
There are 6.
States order.
Yes.
From the above definition, it is clear even that if the goods are foreign origin, if they have been imported and cleared for home consumption, the cease to be the import goods. Therefore, any importer ceases to be the importer. Therefore, no duty can be assessed on such goods under section 17 of the Custom Act. There is also no responsibility on the importer or any other person from whom the goods are seized or keep or produce the import documents to establish their legal import once they have been cleared from home consumption. The goods can be used, sold or resold without any duty either on the importer or any subsequent buyer of such goods to keep or produce the import document. Or of course, if the goods have been smuggled into India, not through the designated custom port, airport or land custom station.
The very fact that your adjudicating authority went to the length of writing 100 pages on the seizure by itself shows the defense mechanism had set in. They will be put to task. Let us write a strong order. But there is no material to write such order.
No, order is too lengthy, Lordship. And
There is no content.
they have dealt with all the 6 drugs. That's why probably it has become.
So, all right, tell us.
No,
Smuggled goods, how do you satisfy the court?
No, because the first, as in a adjudicating order, that they could not produce any document.
Were they required to?
And secondly,
First question first, were they required to? For the purpose of Customs Act. We are not on any other aspect.
no, Lordship, when they,
And if you found that the GST documents were not in order, did you inform the GST authorities?
no, that is with regard to evasion of tax only, Lordship.
So,
Our case is.
did you inform them that their GST or documents are not in order? Take
No, for just
appropriate action.
no, for the argument sake, Lordship, in my humble submission, suppose these documents are, even if it is presumed to be valid, Lordship, they will not absolve them from dealing with the foreign goods, Lordship. And
They are not supposed to get absolved. Burden is on you.
Lordship, the circumstances, first, Lordship.
First, tell us, seizure under the suspicion of being smuggled goods.
Yes, Lord.
It was a random search, as you said.
Yes, it
So the
was a-
seizure was not under suspicion that they were smuggled goods. It was a random check.
in page 102, Lordship.
Yes. Essential commodities application. ECF. One six. 1610. Yes. Yes, anything else to say?
No, Lordship, page 187,
Hmm.
finding why the authority has come to conclusion that it was a foreign goods.
Yes.
Okay, last 7 lines, Lordship.
Hmm.
Page 187, paragraph
Yes.
97.
Yes.
Her claim is also not corroborated by statement of any other person or document. The veterinaries have also been stated to be Myanmar origin by test report of ARDF. Although the authority of ARDF has been questioned by many courts of law.
Otherwise also the report is not conclusive. Maybe. We have just now read it. So report is of no help to you. What are the evidence?
There was a basis of it. On the test report, although it was not accepted by many of the courts.
Otherwise also the report is uncertain. So there is no report. You don't have any other document. Caesar is in India.
Yet it
There are
is,
no foreign markings, no statement under 108.
it is
Yes, please.
the report of page 216, that is there. Lord.
216, let's see.
And we have also annexed one report, how much production is there in Mizoram, page 217, Lordship. That may be also, Lordship may consider them. Because if there is no production in Mizoram, from where they have accumulated such huge quantity of metal lot. This can also be a presumption.
216.
216 is the test report.
No, 216 is that document.
Not 216.
All right, expert investigation agency, Calcutta,
Yes, Lord.
export.
Yes.
That is what the report.
Yes, Lordship.
What the report reads, conclusion.
Conclusion, Lordship, the sample not conform to the regulation, item number 2.3.55.
Yes.
Food
So
and Safety Act.
FSSAI. It's not a prosecution under the FSSAI. Food safety.
Thereafter, Lordship, when they file an application for provisional release, then this honorable court directed us to get the sample tested. Probably in the month of January, December or January, Lordship.
Mm.
The report come that these are not fit for human consumption.
So you returned the goods illegally in monsoon season.
Lordship,
They became unfit for consumption. Now we'll write in the judgment
no,
that you are responsible for that.
not that, that is all, but Lordship, as per the adjudication order, the seizure was legal at the relevant point of time. And appellate authority.
It was totally illegal. You had no material to seize the goods. Even on a prima facie inspection, there was nothing which justified the seizure of the goods. The GST bills were there. That is why we are asking you, where is the interception memo? Does it read that the GST invoices produced are suspicious? Your order doesn't read that.
No, Lordship, with respect
Your
to-
order, which runs into 100 pages,
Yes,
doesn't say a word that at the time of interception, the officer found the GST memos to be suspicious.
Probably that finding is not, there.
So
That finding
it's
is.
a case of gross illegal seizure, plain and simple.
No, Lordship, with the cost of repetition, with regard to GST, not GST invoices, Lordship. This amount, if these are fake or genuine, that is related.
That
to
is not the question, sir. It is neither a case of goods under 123, nor is it a case of goods being transported without valid, without documents. So what business did your officer have to seize it? बताइए.
Well, Lordship, as stated in paragraph 103, first paragraph, there was some intelligence information.
That was for different areas, different
But
things.
in Godown, they didn't find, but while returning from them, they
The
found.
2 trucks were standing.
trucks,
तो क्या करें, किसी को तो ले पड़ेंगे, आज जाएंगे तो खाली हाथ कैसे जाएंगे?
No, Lordship, may please to see, no was there, only the cleaner was there in the truck.
और ड्राइवर को क्या
He-
वॉशरूम नहीं जाना होता है?
No, Lordship, fleet. Lordship, he said that, the cleaner said that they went to the police station to report something, Lordship.
ठीक है,
But when the officer reached
मेरे
there,
ड्राइवर को चाय पानी कुछ नहीं पीना होता है क्या?
but even thereafter, Lordship, nobody returned to the officer, Lord.
ऑब्वियसली टीम दिख गई तो क्या करता बेचारा? उधर भी 5-10 हजार रुपए से नुकसान होगा, नहीं तो अपना आप चले जाएंगे.
Because they are afraid that they will be apprehended when the truck is loaded with foreign goods. Lordship.
Sir, tell us, did you apprehend the truck with any kind of suspicion? No. It was a random check. Documents were found. There were no foreign markings. There was no cause for seizure. Chaliye, anyhow, we'll see. Yes, sir.
Yes,
Please.
my lord. As regard question number 1, the burden of proof under section 123 stands settled by the Honorable Supreme Court. The appellant had raised the same issue before the learned tribunal, before the Meghalaya High Court, and before the Supreme Court. Finally, before the Supreme Court, who has dismissed the SLP filed by the Customs Department in the case of Commissioner of Customs of Alphanpur. I refer Tribunal Order 9/12/20, Annexure 14, page 320.
$320.
320,
Tribunal's order is not binding on us, sir.
yes. Then.
Which is the Supreme Court judgment?
The High Court order, let me read, that
Page,
is 295.
See what happened, similar issue came before the Honorable Meghalaya High Court. That appeal was dismissed and department went to the Supreme Court. That was dismissed on the ground of delay. Lordship. So there was no adjudication.
Meghalaya High Court judgment is there.
My lord,
We
Lordship,
can very well rely on that.
no, Lordship, that, Lordship, please to see that judgment. Lordship, it is a one-page judgment. Nothing was.
So we don't
discussed.
plan to write more. Don't worry.
No,
There is nothing in this appeal, Mr. KL. Not even one para is required. 2 lines. Documents were there. The goods were not notified under 123. Seizure was illegal. Chapter closed. Nothing more is to be written. Malified. Ground for compensation.
no, that is-
2 more lines.
No, Lordship, that is altogether different thing. Lordship, I cannot make comment on this, Lordship. But the adjudication order and the order passed by the appellate authority, Lordship.
SLP has not been dismissed on delay. Delay has been condoned. Read 297.
page of my affidavit of.
Yes, delay condoned. Don't make a wrong statement, sir.
We do not find any good ground and
Delay
reasons
condoned.
to interfere with the judgment and hence the appeal special petition is dismissed.
All right. Law laid down by Supreme Court.
But Lordship, then because there is no discussion.
Don't unnecessarily defend such absurd proceedings, please.
No, Lordship, I'm.
This is height of unethical proceedings by your officer. Totally unethical. There was nothing at all. You see, the cleaner was and the drivers, they didn't have any idea
Yes,
how to respond to 108.
that is.
Right? They would have given out the true version. And they stated, "हमने वहां से लिया है."
That is the.
Then what was there with your officer to seize the things? That is why the seizure is illegal. Not even burden of proof. We go beyond that. Grossly illegal seizure. Because even after searching, you couldn't find anything to justify the next step. Burden comes later.
Circumstantial evidence,
Circumstances leading to the seizure. There was nothing at all which could have justified that action. No foundation.
But the intelligence information was.
Mr. KL,
No, Lordship.
not for these trucks.
Yes, that is correct. That is correct.
Then
They went to some godown, but
that's what we are saying.
they didn't.
कि
find
खाली हाथ क्यों जाएंगे? कुछ तो लेके ही जाएंगे. उसमें तकलीफ हो गई. Yes, please.
High Court order 295.
We have read it. We have read it.
On 29/10/17.
पढ़ लिया भाई साहब. We have read it, sir. Anything more to say?
Then that is, these, all these valid documents are there. Investigation of the driver, place of seizure, investigation of supplier, bank payment. and investigation of party, all these things were done, taken into consideration by the tribunal.
Okay.
So therefore, in absence of evidence by revenue, this should be dismissed as it is already settled by the Honorable Supreme Court.
Very well.
And he raised in the fresh proceeding is not a substantial question of law. Now, second question of law number 2. Question of law, whether Sister Kolkata erred in law in setting aside the order of confiscation when seized goods were found to be unfit for human consumption for test report of Executive Inspection Agency Kolkata. My lord, respondent strongly contends the issue raised herein is a blatant lie, because first test report dated 26/7/18 would show that it is a positive. Para 44 of page 72 SCL
First test report is favorable.
in appeal petition. Para 42, that is the first report after the seizure, immediately after seizure.
What does that report say?
Director E, Regional Plan Quarter Station, South Lake, Kolkata, forwarded test report in respect to the said sample of the seized butter nut, white letter dated 26/7/2018. With the following observation. Observation is at serial number 2, AS 17B7767 track number, type of test, then pathology, free from pathologic infection, then free from insect pest infestation, entomology, and wet signs free from wet seed. That is in case of Nimloni track, second track 0838, free from pathologic infection, free from insect pest infestation, and free from wet seeds. That is in respect of appeal number 2 to be moved up.
Yes.
And serial number 6, track number 8785, free from pathologic infection, that is pathology, entomology, free from insect pest infestation, and then wet signs, free from wet seed. There is
Yes.
another track, Nimnoli. So this test report dated 26/7/18 certified that goods are fit for consumption.
Yes.
Now, thereafter 3 months, on 12, the second food test report was taken on 12/10/18 after 3 months of seizure. So immediately after seizure, there was a good condition. First test report, second food test report after 3 months, para 46.
What you will do, what your clients will do of this betel nuts now? What is the use now?
Now, so it is we have to for compensation. We have to ask for compensation.
You will have to file proceedings for that purpose.
That will be, we will file separate procedure.
Oh, yes.
Now,
There is a
now-
finding of this
now-
honorable court, when they file an application for
So-
provisional release, then this honorable court directed us to get the sample tested. That report
Mr.
is.
KL,
My lord,
first
they are
report
not-
was in their favor. Your seizure is illegal fundamentally.
No, no,
Then
no.
yes, they are entitled. to-
I'm not on that also.
Yes.
I'm just, when they file an application for provisional release, when the appeal was pending, then this honorable court directed us to get it.
Yes, so
that
3
report
months,
is-
that's a ample proof
Yes.
that your actions have resulted
No,
into the betel nut going
no, Lord.
rotting and becoming unfit for consumption.
With regard to question number 2,
Yes,
if the sample is not fit for human consumption at this stage, whether it can be released, that.
they will use it at manure. Why you bother?
No,
They'll do whatever they want to. If they are found selling it, there are different actions in law.
no, that is there, Lord.
So release, how can you resist?
No, Lordship, because there is a finding of this honorable court in this case, Lordship, that I point out.
We are asking you, how can you even resist? Once the order of the sestet is
No, we can-
upheld, it will be upheld for all purposes.
No, for.
We are not giving any further directions.
Not-
Yes, Mr. Council.
Then, my lord, issue of food test is a question of fact, not substantial question of law. Food test is unconnected to seizure and confiscation processing under Customs Act. Food test is nothing to do with the proving of smuggling nature of goods. Issue of food test was raised before the tribunal, who has not considered it in terms of section 144 of the Customs Act and 47 of the FSS Act 2006. Tribunal said it is ill-conceived to conduct so much of food test by the custom without considering its use. So it cannot be issued again in this appeal. Now, customs officer of Korimonshids are not authorized to draw samples and
samples for conducting food tests,
Yes.
and which they have done instead of calling the designated food officer who are the specialized person for that purpose. So it violates section 144 of the Customs Act and 47 of the FSS Act. They have no power.
Yes.
On 144, they can seize only at the when it was in port of import, not in the town seizure or city seizure. They cannot do food test. Then they can go to the fish market and they can they tell that all these fish are being sold, rotten fish.
Yes.
So they have no power unauthorizedly. They have harassed my client for the last 5 years, my lord. I need an order, my lord, to compensate me.
That for that you will have to approach the appropriate court.
Customers, then my lord, to do a sample is a high specialized job. And only the food officers are authorized to draw the sample.
We have
They are
taken
drawing
note-
of sample.
You
They
have
are
taken
drawing
note of
the
your argument,
damaged
sir.
sample and sending it to lab for
We have-
negative result.
We have taken note of your argument.
The-
All right. Yes. That's all.
Another last one, no question of law number 3. Whether finding of sisters are perverse under the present facts and circumstances of the case. Issue raised here is hypothetical and not specific. It is neither a question of fact nor a question of law. List it to be substantial. On this issue, I may permitted to read few citations of the Honorable Supreme Court. Civil appeal, page, para 5, 256 of my evident opposition, 256.
Yes.
256, my lord. In that case, it has been held that second appeal without adhering to the procedure prescribed on section 100 of the CPC, it has further been found in a number of cases that no efforts are made to distinguish between a question of law and a substantial question of law. In exercise of powers under this section, in several cases, the findings of the fact of the first appellate court are found to have been disturbed. It has been kept in mind that right to appeal is neither a natural nor an inherent right attached to the litigation. Being a substantive authoritative right, it has to be regulated in accordance with law in force at the relevant time. The conditions mentioned in this section must be strictly fulfilled before the second appeal can be maintained, and no court has the power to add or enlarge those grounds. The second appeal cannot be decided on merely equitable grounds. The concurrent findings of the facts will not be disturbed by the Honorable High Court in exercise of powers under this section. Further, a substantial question of law has to be distinguished from a substantial question of fact. Then it is not within the domain of the High Court to investigate the grounds on which the findings were arrived at by the last court of fact being the first appellate court. Another, my lord, in EIN 1963 SC 302, Ramachandra versus Ramalingam, Supreme Court held that in the second appeal, jurisdictions of High Court being conferred to substantial question of law. A finding of fact is not open to challenge in second appeal, even if the appreciation of evidence is palpable, erroneous, and finding of fact is incorrect. Now, 2017, 349 ELT 193 Supreme Court in Steel Authority of India case, page 269. 269, my lord. On the basis of discussions have reported, it must therefore be held that before admitting an appeal under section 130 of the Customs Act, the following condition must be satisfied. The question raised or arising might have the direct or proximate nexus to the question of determination of the applicable rate of duty or to the determination of the value of the good for the purpose of assessment of duty. This is a sign of quantum non for admission of the appeal before the court under section 130 of the Act. The question date must involve substantial question of law which has not been
So now the
answered.
appeals have been admitted. While you retrace your steps there, this will be finally decided. Appeal has already been admitted. How these arguments are relevant? Okay, very well. Anything else to say?
No, my lord.
Okay.
Let's see. No, see, but just for clarification, the last test was conducted on the basis of the order by this honorable court. Lordship. The department didn't their own tested.
Maybe.
No, Lordship, just for because my land.
His argument is what business did you have to even draw samples?
No, Lordship, earlier, subsequently, Lordship, and that is for.
First time.
No,
What
first time-
business did you have to draw samples?
That Lordship will decide, Lordship, I cannot.
Okay.
But the second and last was by for the direction of this. Okay. 3 appeals, Lordship, 9, 10, and 11. 3 appeals, 9, 10, and 11.
Arguments have been heard, judgment is.
Much obliged.
Weeks trying to file a reply.
Senior advocates are not supposed to mention for adjournment. Mr. Das prays for time
Yes.
to file an affidavit
Affidavit. my-
on behalf of the respondent number.
Respond number 4, my lord.
Respondent number four. Is
This, your lordship's status quo has been maintained. I told my client, you have to maintain.
Interim order will have to be extended.
interim order shall continue.
It is being maintained, my lord.
Let's make a specific direction. also.
Deeply.
At least of 2 weeks.
Yes.
Wait, please, your lordship. Your lordship, I beg to mention item.
Just a minute. Do you want a date, fixed date, Ms. Das? All right, let it come up 2 weeks. 2 weeks. Okay.
I beg to mention item number 11, your lordship.
Yes.
In the last occasion, the
Do you want a fixed date in the matter?
No, whichever your lordship is.
16th or 15th of.
Yes.
15 June, 15 June. is fine.
My lord, deeply.
State is also to file the affidavit.
Pollution.
PCB, pollution control, the affidavits on behalf of all respondents be filed in the meantime.
Please, your lordship. Your lordship, I beg to mention item number 11, your lordship. On the last occasion, the forest department has filed an additional affidavit, your lordship. Kindly grant us some time to file a reply. Your lordship.
Because
Learned counsel for the petitioner, Mr. So 2 weeks time to file rejoinder in response to the counter affidavit filed by the forest department. Prayer allowed that the matter be listed accordingly.
Obliged.
Item number 1 for orders.
Made, please, your lordship. The connected PIL.
yes,
On the last occasion, there was a direction that they will conduct a
survey report.
survey report and submit.
Lordship, in fact, this is the same river regarding which your lordship is.
Morning, there was
Yes,
another, so
same
we'll take that matter up with this one only.
Yes.
We'll connect that petition to this one.
There's just one aspect, your lordship. Direction was to conduct a satellite survey, your lordship.
Yes,
So getting the satellite survey done was a little difficult for us. We
Why?
had a drone survey, your lordship.
why, what's difficult for the
Some-
state?
No, we are getting it done. Some time, additional time is being required.
That's fine, we'll give you time, that's not an issue.
But otherwise, a drone survey report is there, your lordship.
Satellite survey would give a better idea about it. There is no chance of any discrepancies.
Lordship.
Posted on? We have closed that, right, okay.
Just the stretch of the river is different between both the.
Is it different?
The
So
stretch-
that's the material part is that only.
Yes, sir.
That was limited to a 700
Yes,
meter stretch
yes.
where the mining lease was in existence. Maybe ठीक है, imaging तो ठीक दिया है. Imaging is okay.
It's a satellite here, drone, the image is there.
Image is there. What do you say, Mr. Laskar? The images are very clear. Doesn't seem that any mining activity is going on. You want to contradict this, then take your opportunity and do that. Because what better evidence can we have of mining than a drone image or a satellite image for that purpose?
I don't know what is the date of this photographs, but photographs showing And
let's direct them.
Why don't you file it in front?
I'll file it in the court. Let them file it and then.
Mr. KP Patel, understanding Council Forest Department has raised for it is granted a week's time to bring on record. Drone survey report on the assessment affidavit. In terms of our order dated 24/2023. Let this matter be listed again after a week.
Yes, because they can also do the satellite, also not a very.
Should be 2 weeks,
2 weeks.
after 2 weeks.
They can't be in the meantime, the satellite survey
In
report.
the meantime, the department will also make an endeavor to obtain the satellite survey report of the river.
Obliged.
Matter number 2.
Lordship, in terms of your lordship, last direction lordship, I have obtained some instruction from the department lordship. And there they have stated that so far as sanitary landfill is concerned, lordship, that has been addressed in the DPR itself, lordship. So lordship, I would like to file one affidavit, some technical aspects are here, lordship. Lordship will allow me, lordship, or by the next date, lordship, I will file one affidavit, lordship.
That will be additional affidavit.
Yes, lord.
Hold on. I was reading this, wait. It's regarding that.
In the previous affidavit, there was,
Legacy waste, no?
Legacy waste.
There was.
in the previous,
Yeah,
Bigger matter.
huh? There was one more matter, no? One more regarding the same. When I was looking at.
Small matter, we ask for a policy.
Policy. One of the files today itself, I think it will come out now. There is. The states stand that they already have in place a plan for converting this, using this legacy based on converting it. Abhi आ जाएगा, file will come. How much time do you need?
Lordship, within 1 week time, lordship, I'll file my affidavit.
in the previous affidavit, there was a timeline fixed by, they have given a timeline in para
NGT order. Mr. Advocate. Treating the solid waste. We had suggested that there should be plants for conversion of solid waste to energy. Please read 511. There is something already in place. Maybe you have missed out. 511, affidavit of GMC. So is it the affidavit? The contents of the affidavit are correct or not? Because the Advocate General doesn't seem to have the idea about it.
No, we have, in our affidavit, we have stated now construction.
As per this affidavit, the plant is already functional.
In fact, this was functional. There was another function which was functional, which was abandoned. Now my learned friend was stating about Deepor Bills, that Boragaon's project that we have abandoned because of the NGT's order. Here also we have that energy.
Please read 511 para D.
511.
You don't have it.
511 lordship.
That is affidavit in opposition filed by response numbers 2 and 12. 2, 12 and 14. Railways.
Railways.
So that's a part of the NGT's order.
Yes.
Wherein the GMC has given an affidavit. This is
Yes, Lord.
the reproduction of GMC's affidavit.
This was the earlier project, lordship.
No, not functional now.
This
Is it-
was
is it
abandoned.
not
We have
functional?
abandoned it, lordship.
My lord, actually.
No,
if I
it
may
is
correct-
running.
My learned friend was little bit not clear.
The
We had a project there in Deeporville area, lordship. That is
Chatribar.
called Boragaon.
No, this refers to Chatribar. Read please, para 4.
Paragraph 4, 511.
Para D.
Establishment of decentralized plan. Lord,
Yes.
I just want to see. Which
Please read it, yes.
NGT order.
Yes.
Yes, it was in NGT, lordship. This
This is the affidavit of, this is from affidavit of GMC.
Yes, lordship. This was regarding the project which is now abandoned. It is that project we have stopped because of the NGT's order itself.
After this order.
Yes, Lord.
My
We have
lord,
shifted it
yeah.
to Chandrapur. Now again, we brought it to Belotol.
Yes.
This project was completed project, lordship. We have to abandon because there was a complaint that it is within 500 meters from the boundary of
The bill.
bill. That is why the PIL came up, Rohit Chaudhary's case, lordship.
Okay.
So this project was functioning.
Oh.
And this project was started sometime in 2011-12.
So now you have to shift
We
everything
have to
to
shift.
another.
And they could not produce the optimum.
In the affidavit.
Ramki was doing this project and they could not produce the optimum which they have project regarding this waste to energy conversion.
Okay. So, all right, now what about the fundamental issue right now? Declaration of eco-sensitive zone.
Eco-sensitive.
What is happening on that?
That draft has gone to the central government, will, otherwise railways and the PWD has taken. Now this meeting. That Deeporville railway track mitigation plan, this is being implemented. For that, PWD and railways are working together.
Okay.
There will be elevated railway track and there will be some underpasses. The process has started. Last inspection was on 17/5/2020, few days ago, lordship. And land acquisition process has also started. And it is in, as per the plan of this particular committee, lordship, the things are moving.
Okay.
It will take some time. electrification work was started, but it was stopped.
Obviously, when
Yes.
you want to go elevate the line,
Lord.
the electrification has to wait.
With lordship. In fact, during that NGT case also, NGT also issued one order at one point of time to stop all the construction work of the second track. They wanted to have a second track also there. So I would like to file one affidavit on behalf of GMC lordship where the work, I'll give the status report regarding the new project,
All right,
solid waste.
okay.
And the targeted date initially was June, July. Now it is September, lordship, which is on writings. I would like to file it,
All
lordship.
right, okay. And
And
how
regarding
can we expedite the declaration of the eco-sensitive zone?
that, lordship.
What is the
not
mode?
in our domain?
Here,
We have-
I'd just like to say, under
Yes.
the national, the
Mm.
Environment Protection Act, Section 5, the power flows from it. 60 days time is given.
To the central government.
No, to the persons who will file their objection because they have
Yes.
to regulate it. The land use
Yes.
part has to be looked.
Yes,
And 60 days has elapsed. Now, the state government, the PCCF has filed the affidavit stating that the notification is there, draft. But that unless it is specified, because the precautionary principle
Hmm.
cannot be brought in. If the eco-sensitive, it will be deadlocked. So the forest will have to clearly take up the matter with the central government
Yes.
because under the Environment Protection Act, Section 3 gives plenary power to the central government. So they will specify the date because already 1 year, 2 years have passed. 21 matter. So they can't keep it pending because if they keep it pending, the 17 wetland rules,
Mm.
which the Assam government is now saying will implement because they have to implement, there is no second thought.
Yes.
Central government is implementing throughout the country.
yes.
And that will be of no effect. So in fact, I urge upon this court, at least the time frame may be fixed. The entire thing will, because the learned advocate general has also taken the matter in its right hands.
Let's ask what Saike says. Yes.
Lordship will try to communicate with them. And if the central government is a party. I think they are a
CGC. Deputy, yes. Hmm. Next week. Yes. Mr. Saikia,
Lord.
we'll post it in the next week. Let us clarify the issue regarding ESG. at least.
Lordship.
Eco-sensitive zone.
Lordship.
That part is over, then many things are solved.
Lordship. And in the meantime, GMC's affidavit
Yes,
also I'll file.
Mr. Saikia.
So was
Advocate
affidavit
General-
little bit time, I'm sick.
Mr. Saikia submits that he wants to file a detailed affidavit on behalf of
Guwahati
the
Municipal
GMC.
Corporation.
GMC. In the meantime, steps for ensuring the final notification of eco-sensitive zone shall also be expedited. The information of the relevant procedure being undertaken in this regard shall be placed for the court's perusal on the next date, list on 8th June.
No.
I have some problem on it. Can
Could it
be
be after 13th?
After 13th? Can it
After
be on
15th June.
15th.
June.
Well, in the meantime, I'll also bring in my points
You-
because it's a
you-
PL is basically a collaborative litigation to find solutions.
All right.
Deeply obliged.
Matter number 10.
তার বতা দিয়া
Yes.
Before I could communicate yesterday, lordship, they have already issued the notification. The
That one,
PL.
PLPC?
Yes, lordship.
Okay.
It is more or less in the line of the
Same.
Rajasthan High Court's order.
ये जो रोज रेट चलाता ना कैसे diverted to that.
Three areas they have covered.
Basically, it's a fact finding.
Rural areas,
Yes,
public land protection for municipal areas other than Guwahati. And
yes.
their third one is Guwahati Metropolitan.
Excellent.
And roles and responsibilities of public land protection cell will be. The public land protection cell shall function under the direction, control and supervision of the deputy commissioner.
Yes.
Deputy commissioner shall periodically notify the general public to lodge the complaints representations with regard to encroachment to specific specially designated PLPC.
Mm.
PLPC will depute revenue officials and other concerned departments involved to inquire into the complaints representation received.
Mm.
PLPC shall decide appropriate legal steps for removal of encroachment and take decisions based on objective consideration. To intimate the complaint about the action taken on the respective complaints represented with a speaking order.
Mm.
So this is pure, absolutely following the Rajasthan High Court.
Yes. Just another query which has
Lordship.
cropped up right now.
Lordship.
There we have a procedure called Sampark portal. So the aggrieved persons can put up their complaint online
On a portal.
on a portal.
I'll communicate that also.
You can
It'll be
add that.
easier.
We have our ICT chairman with us.
Yes,
He
Lordship.
will help you.
That will be
Sampark
very
portal will be-
convenient for the people.
It has to be responded immediately.
The public will have easy access. Otherwise, they have to.
Precisely, going there and filing a complaint, and many things can even be done
Yes.
very quickly through the email.
In fact, we have done all this land record correction, etc. through a portal now.
It's online now.
It is online Lord,
Wonderful.
for last 2 years.
Okay.
But Mr. Saika, this is not with regard to entire Assam. Some significant part of the state is not, does not have any record of land record or any, no kind of zonal valuation, etc.
Zonal valuation, even in Guwahati, we are redoing the zonal valuation. In some areas, there are some non-cadastral villages also. So these processes are going on, Lordship. It will take some time, but the process is on for last 2 years and it is a very successful story till now. Lot of people, 80% of the people who are having land issues for last decades, it could be solved in 2 years' time. We have done it already.
This will probably of a great help to the authorities themselves.
Lordship, both it is a win-win situation for both, Lordship.
Precisely.
When I see encroachment in the hills, I always feel where to put the complaint. So now
the-
there will be a
that
complaint, there will be a
mechanism is there.
speaking order.
Mechanism is there and it
Yes.
has to be addressed.
And if the speaking is not satisfied, they can always come under 226.
Then of course, 226 is available. Okay. इसी में क्या था शायद? Yes. Precisely. 2nd March. Yes, yes. ये रास्ता में होना चाहिए. So, okay. Now what remains in your case, sir?
Lordship, since it is admitted that our land was acquired illegally encroached, Lordship, our case also being placed before the committee.
PLPC, all right, you go and file the application to the PLPC now. PLPC will take it up. All right. Then Advocate General is placed on record. The notification dated 24th May 2023 issued by the Revenue and Disaster Management Department, Settlement Branch, Assam, as per which, public land protection cells have been notified for 3 different categories. Number 1, rural areas. Number 2, municipal areas other than Guwahati. And number 3, Guwahati municipal area. The cells have been empowered to redress the grievances related to encroachment of pasture land, catchment areas, ponds, rivers, lakes, public places, burial grounds, etc. We feel that with the constitution of these cells, the grievances of public at large pertaining to encroachments on these categories of lands would be redressed at the ground level, and the litigants would not be compelled to rush to the courts for every smallest infringement. We appreciate the efforts made by the state government in this regard. The petitioner is thus relegated to approach, petitioner who has raised a grievance of encroachment on Kabristan land, is relegated to approach the PLPC concerned for ventilating his grievances. Needless to say that the PLPC shall address the grievances of the petitioner in light of the notification. Supra. You will be heard that PLPC has been given all powers. That is already there inherent in the notification. Needless to say that the PLPC concerned shall, before taking any action of disposition, etc., comma. Here the party is concerned.
That portal which we have done for revenue department and which is very secure, that is called Vasundhara.
Okay.
Vasundhara.
Land, the PIL petition is disposed of with the above directions and observations.
Highly obliged.
We will add one thing. The complaint may be filed by the petitioner along with a copy of this order within a period of 15 days from today, whereupon, comma, the PLPC, after hearing all the parties concerned and making the necessary inquiries, comma, shall decide the same by a reasoned order within a period of 3 months from the date of receipt thereof. In case, comma, the petitioner is aggrieved of the reasoned order so passed, comma, it shall be at liberty to petitioners, they shall be at liberty to assail such order as per law.
Highly obliged.
Letter number 12.
My lord, that regarding, my lord, is so much of PL, my regarding illegal mining on my lord Patkai Hills, my lord.
So आप deal करो सर. Yes.
Already there is an inquiry commission, my lord, Justice, Honorable Justice Kotoki, my lord, commission report has been submitted, my lord, and now, in fact, my lord, they have to.
Today, the matter is fixed for vacation, in the PIL, the so moto, my case.
Is also
Order was
tagged.
passed by your lordship.
Yes,
With your lordship's leave, can I make a mention?
yes,
On
yes.
the item number. There were two PLs. One was PL 29, where your lordship finding that the central government has not given stage 2 clearance, as rightly stated. It is at that stage that the Coal India now files a vacating application to which we are filing the objections. And in fact, in PL 29, there was an order of your lordship in terms of the Supreme Court's order, the Home Commissioner and the PCCF, Police Commissioner, Home Secretary and the DGP Assam were to file a compliance report. The lordship's order is of 27/4/2023.
Where is the IA, order of IA? But it is the order. Main order. No, this is the order.
Item clear.
Yes.
So that's not.
Compliance.
Report.
But only one submission. On the last day, I made a submission that since the injunction order has clearly stated that the central government will take the call, till it is not notified, you cannot go on mining because there has been violation. In item 17, I took up on the last occasion stating that the leases are still operating. And if the stay is to be given full effect to, till the time the stage 2 clearance is not given, the leases part may be stopped for the simple reason that the violation has been, that how it is being violated has clearly been stated in Justice Kotoki's report, which I have brought in clearly saying that without lease, they are what the lordship, the Coal India is giving lease for 30 years and 20 years simultaneously. In fact, Justice Kotoki, if I may take your lordship to item 39, PL 39,
because on the last occasion, time constraint was there. So I'll just take your lordship to page 46 of my 39 PIL 39, which will clear it up. All were unregistered leases. Well, there is a limit to illegality. And it is in violation of Goa Foundation's case because the Assam government says that we have the right to lease it perpetually, oblivious of the fact that in 2014, the Supreme Court has laid down the law, no renewal, because renewal can take place only the FC clearance and all has to be seen, and central and state government will take a conscious decision on two conditions, environmental imperatives and development. And in Assam, nothing has been done. So, Lordship, I'm taking page 46, Annexure 3, which is a part of the report of Honorable Justice Kotoki.
PL 39.
Yes, PL 39. Item 17. And in fact, he makes a scathing remark of two officials, high ranking, who gives clearance in Assam of FC Act. They filed an order, they passed an order that it will be for 30 years lease.
You're referring to
Lordship, page 46. Yes, they're relevant. The Lordship will come to 3.10. This is the report of Honorable Justice Kataki. Validity of the unregistered, if your Lordship allows. Page 46 is the relevant part, 3.10, down below.
This Justice BP Committee
Yes,
Commission was.
he was
constituted pursuant to
constituted
High
by
Court
the
Act.
Assam government because of the massive public outcry. And he gave a report, he made a serious indictment that there was
So
no.
has this report been accepted by the state government?
Yes, the justice report was, Honorable Justice Kotoki's report was accepted, placed in assembly, because under the new inquiry commissions, it has to be placed. Well, if I may read that. Your Lordship, I can clear my points. The MMRD Act imposes
Which page?
page 46 of PL 39. Annexure 3. Because he has given a very voluminous report, 2000 page. I have brought in my part.
MMDR Act.
Yes, Lordship. The
3.10.
yes, that is the relevant, which answers the query.
Yes.
The MMDR Act imposes general restriction on undertaking, protecting and mining operation without obtaining lease or lease as provided in section 4 thereof. Subsection 3 of subsection 4 empowers the state government after prior consultation with the central government and in accordance with the will of state under section 18 to undertake reconnaissance, prospecting or mining operation with respect to any minerals specified in the first schedule in any area within the state. Coal and lignites are specified as hydrocarbon energy minerals in part A of the first schedule. Section 13 of the State Act is the rulemaking power of the central government, in exercise of which 1960 rules were framed. Chapter 4 of the said rule lays down the manner of filing the application for grant of mining lease and the renewal thereof. Section 31 provides for execution of the lease deed in Form K or in the form as near thereto, as circumstances of each case may require, within 6 months of the order, within such further period as the state government may allow in this behalf. If no such lease deed is executed within the said period due to any default on the part of the applicant, the state government had a power to revoke the order granting the lease, and in that event, the application fees will be fixed by the state government. Sub-rule 2 of 31 of the state rule specifies that the date of commencement, this is important, of the period for which a mining lease is granted shall be the date on which a deed under subsection 1 is registered. This is important. Section 13 of the Registration Act specifies the documents which are compulsorily registrable under the said act, which include leases for immovable property from year to year or for any term exceeding the year or receiving yearly rent. Section 49 of the said act provides the effect of non-registration of documents which are compulsory registrable. It specified that such document is not registered shall not have any effect on any immovable. It is. Yes. Mr. Honorable Justice Kotoki was not given the lease also. He has specified. It is evident from the deposition of the Director of Geology and Mining, Government of Assam, that the lease deed pursuant to the aforesaid orders dated 22/7/19 and 6/12/19
extending the period of lease of aforesaid 4 coal mining lease in favor of NECCL was executed in 27/1/21 between the state government represented by the Director, Geology and Mining and NEC. These leases, deed shape, has not been registered till the date of its deposition as required by the Registration Act. The leases between the state government represented by the Director and the Mining and the CEC, that is the coal, was executed on 21/3 after the renewal was granted by the Assam government on 23/9/2008. The Director in his deposition has also admitted that the said lease deed has also not been registered as required by the Registration Act. As discussed above, though the government of Assam Mines and Mineral by the aforesaid orders dated to 22/7/19, which I have challenged,
Is not permissible.
extended the period of lease from 2003 to 2023, such retrospective renewal of lease is not permissible in view of the provisions contained in sub-rule 2 of the 31, which provides for commencement of the period of mining lease with effect from the date on which a duly executed lease is registered. Similarly, the lease deed in respect of Lido executed on 21/3/9 has also not been registered under the Registration Act. The aforesaid lease agreement having not been registered as yet, the period of such lease cannot commence prior to the date of registration under the said Act. Consequently, the NECCL do not have any lease in respect of the aforesaid mines with effect from the date of expiry of 30 years lease granted after coming into force of 73 Act from the year 2003 till date. Section 4 of the MMRD have imposed the restriction on carrying out any mining operation in any area without obtaining a lease from the competent authority. The NECCL could not have carried out any mining operation in the aforesaid mine, which includes the TICOG OCP in the Saleki. Such mining activities on the part of NEC therefore is illegal, being not permissible under the provision of the MMRD Act. The contention of the NECCL as projected in the written submission file that in view of the communication of the government of Assam, this is the stand now, my lord, of 2004, this is very crucial, I have an answer to it. Issued by the government of India, Ministry of Coal and Mines, the period of lease of the aforesaid coal mine deemed to have been extended cannot be accepted in law as well as in fact. This is a categorical finding. By the said communication of 2004, the CIL was informed about a decision taken to consider a request of the coal companies to authorize working of the lease for a further period of 30 years beyond the lease period for which the coal companies were required to submit their proposal with details of the area whose lease has expired. In no stretch of imagination, it can be said by the said communication of 10/8/2004 that the period of the expired lease has been extended or deemed to have been extended. No order of granting lease for a further period after expiry of the earlier period was passed. The central government also did not pass any order in exercise of power of relaxation conferred under 31, which empowers the central government to pass an order in writing in the interest of mineral development, authorizing grant, renewal or transfer of any permit, license or mining lease or the working of any mine for the purpose of searching for the winning or any mineral on terms and condition different from those laid out in Rule 13. The Standing Committee of the National Board of Wildlife in its meeting of 5/10/20 decided to send 2 members of fact-finding team comprising of officials each of MOE and C, Government of India and the Forest Department to submit a factual report. The 2-member, this is important, the last page. The 2-member committee consisting of the Deputy Director General Central, Shillong, and the Government of India, and the nodal officer, the FC Act, Assam Forest Department, has therefore been constituted, who on the basis of a site inspection conducted on 10/2/2020 to 12/2/2021 submitted the report which was placed in the 61 meeting of the Standing Committee of the National Board of Wildlife held on 18/2/21. Decisions of which, however, was deferred as the same required further examination. The said report therefore has not been accepted till date. But the last paragraph is important. 3.17, in the said report, though it has been observed that the lease in favor of the aforesaid mine become automatically validated up till 1/2/2003. Well, Lordship will see 23 and now they go to 33. But whims and caprice. The said observation of the committee is not acceptable in law as well as in facts for the simple reason that the central government did not exercise the power conferred on 31 of the MMRD Act. That apart, had the mining lease already been extended till 1/2/2033, there would not have any occasion on the part of NEC to apply for renewal of the lease to the Mines and Mineral Development Department and the subsequent orders passed by the said department extending the mining lease for 20 years till 2023, which I have challenged now. The commission, however, has found that such extension of mining lease has not come into effect till date, as the lease agreement executed thereof has not been registered as required under the Registration Act. The commission fails to understand how a nodal officer of the Assam Forest Department, as well as a Deputy Director General of Forest Central, could record such a finding which has got no factual basis. This activity on the part of few officials creates serious doubt about the intention to stop illegal coal. So my contention is that since your lordship has already clearly passed an order stating that the stage 2 clearance is not there, you have converted the land into revenue land, we are injuncting it. The central government will have to file their affidavit making the stand clear. This mining lease in PL 21 cannot now operate. Because now what will happen, taking a cue that the Assam government has extended it, and the central government through the letter of 2008 has also leased it till 33, we can go it. Oblivious of the fact, till now, the central government has not been able to show, and the state government, no FC clearance is there, especially after the Godha government. So in my respectful submission, we will file our affidavit, let this case be monitored, because in PL, the monitoring has brought about a lot of good things. But I want that this part, the leases need not be given effect in view of your lordship's order of PL 29. That's my submission. And we'll file detailed affidavit countering everything.
What is the central government's stand on this registration part?
Malad
Chaudhary?
Yes. Central government has supported our case in PL 29. In 39, I don't know.
Lease is not being registered. What is your stand? This Chaudhary, there's a phrase for this, Bagle Jhankana. Whosoever is there. Madam, what is your response to this?
It is that they have not filed affidavit till now, my lord. Instruction has been received from the forest department.
Why? They are not answering to your calls or what? Call the officer here, keep him personally present. Call him. We'll direct them. What is the state stand?
Yes.
Madam Bhattacharjee, what is the stand of state? How are the mining leases being operated without an extension is being granted, without the same being registered?
30 years, His Lordship, it was a little bit old Lordship. On June 22, the affidavit was filed by the Deputy Commissioner at that time. Lordship.
Without registration, that is a specific ground raised by the petitioner.
Lordship. Lordship, we may be allowed time so that we can file the updated one, because on past 1 year, what actually has happened, Lord.
This is of a period prior to 1 year. Specific ground, without registration, no mining lease.
Lordship, I don't have the current page number, Lordship, that has been filed by the Deputy Commissioner, Lordship. Here in paragraph 3, that is misstated, Lordship.
What is this?
Hmm?
Read please.
No, this is this particular PIL.
39.
Three,
Yes,
20.
39. Read. Affidavit in opposition by
By the Deputy Commissioner, Lordship, the nursing power, Lordship.
let us see that.
Right here.
Not there. In this, there is no affidavit. No, is there affidavit opposition?
To my knowledge, no affidavit has been filed by.
No affidavit still.
No affidavit.
In.
Only Coal India has.
39.
39.
What has the Coal India said to this,
Lordship.
this assertion? What does the Coal India say, Mr. Das?
Yes, Coal
this
India
is-
basically says that we have a lease, we can, in 2004, we could extend it, but in the order down below, they say that they can be done for the energy security subject to compliance of the environmental.
No, regarding your ground that it is not registered.
No,
What they
that
have
is
said.
the ground, because that is the ground on which I am harping. If
They have not said anything about that.
they have not said anything, they have not said, they have not answered anything.
We have filed an affidavit. It's not on list today.
It's not on record.
No, not only.
All right, we'll ask all the respondents to answer this
Yes.
pertinent ground. The petitioner has taken question. PIL number 39. The petitioner has questioned the extension of mining lease granted to the CIL by the state.
Well, if our lordship may specify.
Where is the
order,
extension,
yes.
extension order?
The extension orders are at, my lord, in the operative part, page 32, I have given the detailed list of the four extension order. 22/7/19,
32.
my lord, page 32 of PIL, the prayer
is-
portion, I have specified. I have mentioned the names also, the leases.
Just.
Yes. A, B, C, D. The Lekha Pani team for Pani.
Yes, question the extension of mining leases of the respondent Coal India Limited in terms of prayer clauses A, B, C, and D of the writ petition on the pertinent ground that as the FC was not taken and since the leases were not registered, comma, the extension could not have been ordered. We find that till date, the senior counsel representing the, Mr. Ahmad representing the CIL submits that he has filed detailed affidavit has been filed on behalf of the corporation, which may be brought on record. We find that till date, affidavits on behalf of the state authorities and the Union of India have not been filed. And counsel MS Gayan, representing the Union of India, submits that in spite of instruction given to the concerned official of the MOEF, comma, no response has been received till date. Who would be the officer at Shillong? What would be the designation?
My lord, the central officer will be in the rank of conservator, who will be representing the central government, the eastern zone.
Yes, the respondent number 2. But you not given out the designation of the officer.
No, my lord, your lordship can very well direct the central governments because the director of mining is a party for the simple reason because he could not also give.
Affidavits on behalf, we hereby direct that affidavits on behalf of the respondents numbers 1 and 2 shall positively be filed by the next date of hearing, failing which we shall be compelled to require the presence of the Secretary, Government of India, MOEF in these proceedings. Affidavits on behalf of the state authorities be also filed by the next date of listing. Re-notify. The affidavit filed by Coal India Limited shall be brought on record. Re-notify
Objection.
on, oh, you do that. Re-notify on 8th June.
Since I have.
Oh, you're not here on 8th June, 15th June. Interim order shall continue then.
Well, interim order earlier passed.
Interim order passed earlier shall continue. 14, yes. Here. List तो आ गया Yes. What do you want to add?
Yes, your lordship. Lordship permits me. I have made a compilation, your lordship. For your lordship convenience, because the documents are very voluminous. If lordship permits, I'll just hand over the document.
What is the issue involved in this petition?
Yes, your lordship. The issue is, I am just complementing to what
Listed after 20th July.
lordship.
2020. Why the matter was not listed after 20th July 2020? What is the reason?
Lordship,
This case,
it is connected with the
it is
other-
connected with those
connected-
petitions.
Connected with the other matter.
Okay.
So
So what is the issue raised by you in this petition?
yes, your lordship, my issue is more or less same, your lordship.
Hmm.
Mr. Das has been appeared in the PIL 29, your lordship.
So all right, we'll consider it together.
Okay.
Why a separate hearing unnecessary?
Lordship,
Why multiply the proceedings?
lordship.
List on 15th June along with other similar matters.
Well, only one with your lordship's leave, I'd like to say, since the leases, specific prayer for passing an interim order on the leases, that may be specified. Because the earlier order gets, because your lordship had.
We are
passed-
not presently staying the leases.
Yes, yes.
We are not doing that. Let's have the affidavits, then we'll consider.
Other earlier order.
The earlier order is in force.
Many activities have already been stayed.
That mining activity has already been stayed. What more do you want?
Yes.
Shylock's pound of flesh. PIL 3 में क्या करना है? What, Mr. Mahanta, what is to be done in PIL 3?
Same issue because.
Same issue, all right. List on 15 June.
Item number 18.
Yes, issue is small. What is? Yes.
Please, your lordships. Lordships, I would.
Yes,
I would request your lordship to have a look at your lordship's order of 30th of March.
20th March. 30th.
GMC is directed to bring on record complete details of infrastructure already created or in the.
This is for the drinking water.
Well, they have, yes, Milord, this pertains to drinking water.
17th March, you're saying.
30th of March, Milord. 30.
Yes,
Your lordship, it's not details.
you have filed.
affidavit filed by the GMDA. So that too is.
We were hearing the Advocate General. There are schemes in pipeline.
Seems in pipeline 2024, GMD will complete it. Another, in the meantime, one organization which is conducting all these things had abandoned us. We have terminated the contract. It will take some more time beyond that, my lord. Entire Guwahati will get the drinking water. Even now in the area we are giving it, persons,
You got the
users are not
affidavit.
taking it.
I have,
Taking the
Milord,
connection.
I wish to, if your lordship permits, I'll just point out one aspect, Milord.
Yes,
Milord, your lordship has the affidavit filed by respondent number 3. This pertains to southwest phase of the project. Well, your lordships will come to paragraph 2.
you have got an affidavit of Mr. Santanu Bora. Have you got that?
Yes.
Therein all the details are given in para 2. Schedule plan of Guwahati Metropolitan Drinking Water and Sewerage Board to the citizens of Guwahati city.
Your
You don't
lordship,
have that.
your lordship is referring to page 362.
355. Don't have it.
355 I have,
Yes.
Lord.
So the entire detail is given out.
Yes, this is the prior affidavit,
Yes.
the affidavit which has now been filed in May is pursuant to your lordship's order of 30th March. where
Okay,
your
okay.
lordship had asked for details relating to the
Yes.
infrastructure.
Yes.
Now, your lordship will have paragraph 2. Here, they have given the small table, but I must say, Milord, this doesn't have any details relating to any infrastructure. A, Milord. B, your lordship, what is very curious here is that the progress in 2018 in the project was 95%, Milord. And that is as per a statement of an honorable minister, Milord, which I had enclosed with my PIL. The physical progress was 95% in 2018, Milord, for this particular phase, southwest phase. And now, Milord, it is 65 to 70%.
Very perfunctory affidavit, Mr. Commissioner. Very cryptic.
Why it has come
Then,
down,
my lord, and the right-hand column, my lord, the right-hand column says that the contract has been terminated and it is being processed to award the contract. It is targeted to complete the balance project works within 25 months from the date of award of the contract. A project, the physical completion, progress of which, my lord, was 95% in 2018, my lord. Today, it is 65 to
You're reading at
70%.
which page?
My lord, 363. I'm so sorry, my lord. 363.
All right, I was having respond number 5 second. Yes.
I'll come to 5 also, Miller. First I thought this is because.
No, no, it's okay.
Column
it's okay.
percentage of work as per random assessment made by the present PMC, the project after experiencing damage caused to the various creation asset of the project. So far, the percentage of work completed is found to be 65 and 70.
So there was
In the
damage
meantime,
on,
damage is-
on for what reason was the project damaged?
Well, wait a minute, because my lord, when the project is being built, other organization who create roads and other pipelines are built, then the damage takes place, excavations takes place, GMC makes.
So give a proper affidavit, detailed affidavit.
I'll-
This is
another-
perfunctory on the face of it.
Not
So,
11
and then I will
affidavits have
file
been filed till
detail.
date in this matter.
We asked you to give a detail.
I will file my lord.
Page
You have mentioned that you have filed a detailed affidavit.
This is for by the GMD. Another affidavit is there. by
That is
the-
again 3 pages.
But I'll come to that if your lordship may just have a look at page 155, my lord, of my PIL. This is the statement, my lord, I was referring to, which was made on 26 September 2018. 154 of my PIL, my lord. Is the statement made by the honorable minister before the assembly, and at page 155, my lord, the same phase, southwest phase. My lords have page
Yes.
155, my lords. The queries are, my lord, in the previous page at
Southwest.
154,
Full swing,
southwest,
completed by end of June.
expected to be completed by the end of June of ensuing year, that is 2019. Then your lordship will have the last paragraph of this. Last paragraph is of this.
Yes,
my lord, where the
93 to
physical-
95.
93 to 95%. my lord. My lord, then coming to the other affidavit,
Because new PMC had been appointed. They made a survey, then they found it that it is not 95, it is below that.
So this slipshod kind of work performance, one contractor comes, he says, do it in this manner. Another comes, he says, do it in this manner. Ultimately, the public money is being spent. Who is responsible?
No, that, it is there, my lord. The public money is involved.
You just can't repeat these works over and over again. It's we the taxpayers who are paying the money.
The project should have been completed long back, but in the meantime, the main contractor has left, terminated, then we.
It's at 93 to 95%. Suddenly it goes down to 65%.
But new PMC had made a survey. Then it's.
So what action you have taken against the earlier contractor? This is a false statement then.
No, earlier contractor has been terminated, now we are facing arbitration cases. They have filed 2 arbitration cases of.
That is happening everywhere.
the other affidavit, if your lordship may have, this is by R5. My lord, it's 18th May 23. If
Yes.
your lordship may kindly come to page 366. My lord, another 2-paragraph affidavit this is.
Yes.
And the table, my lord, this pertains to south central and north phases of the project, my lord. My lord, this says 75.57%. My lord, the second column from the right. Percentage of work schedule, 75.57, my lord. Overall physical progress till March 23. My lord. Here I must point out, my lord, in 21, my lord, the physical progress was 70% for South Central
and 79% for North, my lord. This your lordship will find at page 27.
We are not satisfied, Mr. Counsel. Keep your officers present in the court next date.
I will file a
Keep both the officers present in the court with the affidavits. The,
My lord, one last thing, if your lordship may just permit me. My lord, I had filed a very detailed affidavit, my lord, on 28th of April 22. My lord, giving details relating to the infrastructure, my lord, page, my lord, 28th April 22, my lord. An affidavit on behalf of the petitioner to place on record the status of different zones.
yes.
My lord, page 6 of that particular affidavit had given details, my lord, on the funds, on the contractor. Does my lord have it, my lord? Well, the middle column, my lord, gives status as per the petitioner, work order issued on so and so date. I've given details here relating to the work intake point, water reservoir, water treatment plant, distribution network, water supply. Each and every detail I have given for each and every phase, my lord.
We will call both the officers in the court.
My lord.
Heard learned counsel for the parties. A perusal of the affidavits filed on behalf of the respondents numbers so and so in pursuance of the order dated 30th March 2023 would indicate that the contents of the affidavits are perfunctory to say the least. No details whatsoever have been given regarding the works in progress regarding the water supply of leak distribution in the Guwahati city. Furthermore, the averments made in the affidavit are contradictory to the material available on record of this writ petition. Thus, the officers in charge of the respective offices, that is
GMDA.
For all the phases, my lord, there are different officers, my lord, for all the phases.
we can't now ensure that all officers should remain here. That's not possible. The
Chief Executive Officer, GMDA.
Commissioner GMDA. Chief Executive Officer GMDA and the Managing Director, Guwahati Metropolitan Drinking Water and Sewerage Board shall remain present in the court on the next date, 8th June.
15th June, if possible, my lord, I can be present on.
All right, 13 June,
15th June is
15 June. All right.
deeply obliged.
Number 19.
Oh, yes, yes, yes. Okay. Everything. Particularly, आज खाड़र वाला अपने कर ही दिया. Yes.
Lordship, on the last occasion, Lordship wanted the officer, concerned officer of the Pollution Control Board to be present
Yes.
before the court with the records. It is
Yes.
with regard to establishment of a brick lane. So the records are with me. We have already filed an affidavit. So in the filing the affidavit, the petitioner's basic contention is that the brick lane has been established in a thickly populated area. And that part has been mitigated by way of our affidavit. We have given the details. Before establishing the brick lane, all the necessary documents has been submitted before us. And petitioners, another big contention is that no public hearing has been done before the issuing the consent to establish. And for, in reply to that, we have already given the detail as to when the public hearing has been done in presence of how many people.
Okay.
And in reply to that, again, the petitioner has come up and said that so-called public hearing has been done. So he's contradicting his own
His
stand.
own stand.
Yes,
Okay.
already the basic parameters of establishing a brick lane has been followed by the private respondents, and we have gone into all the details, and this consent to establish has been issued. So these limited contentions has been prayed before this court, and we have already controverted the allegations.
Well, my basic case was, first of all, the violation of the distance norms. There are certain criteria to be followed. Population pattern is to be seen. There cannot be brick lane within half kilometer. If there is a population of 150 and 20 houses. That was one aspect that is the violation. There is much more thickly populated area. Secondly, it's an agricultural land.
and my lord, the conversion, I'll show from the records, my lord, there is my lord, something wrong with the conversion because the date, my lord, on which they have applied for the consent.
The conversion order is under challenge in this writ.
No, my lord, it is not.
Can it be done?
No, not in the
Then-
challenge district, my lord.
then-
Because, my lord, in fact, my lord, there is no conversion at all, my lord, being placed before lordship. What has happened, my lord, this is an agricultural area. And my lord, lordship will, my lord, see, my lord, the.
Where is your averment and what
Yes, my
is there stated in their affidavit? Let
yes,
us see
lordship will kindly look at my,
on
my
this
lord,
aspect.
para, my lord, para 9 of my affidavit, page 13, my lord, of my writ petition.
Writ
my lord.
petition, page 13.
Yes.
Read.
My lord, that the brick lane in the name of so-and-so has been operating by violating the norms.
Is situated in an agricultural land.
No, that
Let's
is one.
see
my
the
lord.
response.
My lord, first of all, my lord, that's the violation norms, of the distance norms, my lord. I've given the number of households, my lord.
Various norms is a very vague term.
My
What
lord.
norm has been violated?
My lord, specifically, my lord, I'm giving the regulations, my lord. Regulation 2, my lord. There's
Oh, you have to make a pleading
Yes, my
that this is the norm which has been
Yes, my
violated.
lord. My lord, paragraph 9, my lord.
Yes,
My lord, the land surrounding the brick land is also an agricultural land, as will be evident from the photographs annexed here and below.
yes.
The area is about 120 houses, housing a
Yes.
population of 650 persons within a radius of 500 meters. The area is thickly populated and there is also a school in the same area called the Borbola LP School.
Hmm.
There is also a masjid, which is in the Mikirgaon Bara Masjid within the same half-kilometer radius of brick lane. Thus, rule 2, 1 and 2 stand violated by establishment of said brick lane.
Hmm.
Now, these rules, my lord, the deputy commissioner on the other hand filed an affidavit, my lord, confirming, my lord, there is a violation, my lord. So the pollution control department has taken a stand, my lord, the stand is very vague. They have said only thinly populated. They have not controverted, my lord, by making, my lord, specific statements.
What does the rule say? Read.
The rules, my lord, that I've just read, my lord, this is a part of the rules, my lord, I just read, my lord.
In fact,
Regulation, ma'am.
Lordship, before Lordship goes into the so-called rule that he has placed, this is, there
So-called
is,
rule is
yes,
rule.
there is no rule. There is no rule.
No,
This is only a guideline, in fact.
No, my lord, it's a
There's a
regulation.
brick
It's-
lane manufacturing.
No, my lord, it's under, my lord, under the section.
These are
54 of the-
rules.
What rule?
It's
These
Assam
are
Brick Lane
statutory rules.
Regulations, my lord, statutory rules, my lord.
Regulation.
Regulation, my lord. In exercise of the
This
powers.
is a reg-
The regulation rules,
In exercise-
establishment and regulation.
This is a guideline.
Are you sure?
Yes. In fact, I have the copy of it.
This is an exercise of
the
the powers
guideline
under-
of brick lane manufacturing industries. So this guideline has been
The
sent across.
state of Assam makes the following rules, so and so.
Exercise of powers.
This is specifically quoted by petition also, my lord.
Hmm. So
Well,
these are not rules.
Yeah.
Are you sure?
No, actually, I was supporting this one because that thing I have come across now.
No, you didn't read the
Because-
petition.
Yes.
He has quoted the rules in the petition.
Yes, yes, I have an answer to that. In fact,
Yes.
as regard the population pattern and the demography that has been submitted, the deputy commissioner has come up with a very detailed affidavit whereby he has given the population pattern of that area. And in that affidavit, he has stated in fact, I am unfortunately, I don't have the running page. There is a 2-page affidavit filed by the deputy commissioner. In page 4, paragraph 4. Here he has given how many the population pattern of that area.
Running page will be 180, my lord, 180 or 81, my lord.
180.
180, my lord, there's something wrong maybe in my number, my lord, in my numbering, my lord. Either will be 180 or 181, my lord.
Yes. Prakash Ranjan.
Yes, my lord,
Yes.
Prakash Ranjan, my lord.
Yes.
Yes. So the second page of it, paragraph 4. Thus, as regard the statements made in paragraph 9 of the CPL, the reporting text to state that as per the report of the circle officer, Mikiriveta Revenue Circle, the class of land in which the brick lanes is situated in industrial class and surrounded by land of the brick lane are agricultural land. Here, subsequently, he goes on to describe how many persons are residing in that area.
Borbula LP school is situated
Yes.
at a distance of 405.
Yes, if at
Read
all-
rule. Read the rule 2-1. 2-2.
Regulation. Yes. give it proper regulation. Yeah.
2-2. The aerial distance of brick lane shall be at least 500 meters from the area like registered hospitals, schools, public building, religious places, or a place where flammable substances are stored. Brick lanes shall not be allowed within a radius of 1.1 kilometer in notified sensitive area like Jew and so and so.
So
Yes.
500 meters.
500.
The deputy commissioner says school is at 400 meters.
There's also masjid, my lord, within the AB, my lord.
Masjid is 495. We can give them a tolerance of 5 meters.
My lord,
Yes, gentlemen.
In fact, again, going by the location of the land that we are guided in the guidelines of the brick lane manufacturing.
These are statutory rules,
These
gentlemen.
are the statutory rules we have.
Probably your authorities are not aware of these rules.
In fact, yes,
You want to revisit your action in light of the rules?
yes, I would like to rely on that rule and come up with my subsequent reply.
All right. And counsel, the petitioner has drawn the attention of the court to the Assam Brick Links Establishment and Regulation Rules 2013. And to be specific, clauses 2.1 and 2.2 thereof, and urges that considering the fact that there is a school located at a distance of 405 meters from the brick lane in question, comma, the same is operating in violation of the above rules. He further submits that the brick lane is being allowed to operate in violation of the requirement of Rule 2.1 as well. And counsel appearing for the Pollution Control Board submits that he was not apprised of the rules of 2013. He was not aware about the rules of 2013, and thus, comma, the averments in reference thereto could not be incorporated in the affidavit filed on behalf of the board. We hereby direct that the entire record shall be examined, re-examined, record pertaining to grant of permission to operate the brick lane shall be re-examined in light of the rules of 2013, and the correct facts shall be brought on record by way of an affidavit list on 22nd June.
Also, should the officer's presence be again?
Yours,
Can his presence be dispensed or
the personal presence of the officer is dispensed with. Officer so and so is dispensed with for the next date of listing.
Obliged.
Done. Okay.